Well, good evening. Happy Thursday. Happy Thursday to all of you. Good evening to those of you tuning in live. I apologize for being a little bit late, but you know what? Time is a construct. I hope you guys had a wonderful, wonderful Thursday. For those of you listening, you probably hear that I'm still under the weather. Don't worry, I am taking appropriate medications and doing all the things I need to do. But if I go mute for a while or a minute, it's because I'm coughing. I don't want to cough in the microphone. I don't want to disturb you guys. We had a interesting day in court today in the Maya Kowalski case, and we've got a recap to those of you on the replay crew. Good afternoon, good evening, good night, good day, good morning, whatever time it is you're tuning in on. We love having you here. Please go ahead and make sure you hit the like button on your way in. It's really easy, just a little button, says thumbs up. And if you like the content, please go ahead and subscribe. So today we're continuing our coverage of the Maya Kowalski case, the case of Kowalski versus Johns Hopkins All Children's Hospital. This is a case with the facts having been documented by the Netflix documentary Take Care of Maya, involving a child, Maya Kowalski, at the age of 10 when she was admitted to Johns Hopkins All Children's Health in October of 2016. October 7th, Maya Kowalski was admitted with acute pain in her stomach and abdomen, and very shortly thereafter, she was admitted to the PICU, the Pediatric Intensive Care Unit. That began a series of events that ultimately resulted in Maya Kowalski being the subject of a detention order, a shelter order by the court after DCF, Department of Children and Families, became involved. There were allegations of Munchausen's by proxy on the part of the mother, and those are suspect because Maya was admitted with a diagnosis of CRPS, complex regional pain syndrome. It's rare in children, less rare, as I'm learning day to day, in adults. So this is a case involving chronic pain in a child and medications such as ketamine being used to treat that child. The allegations are really sensitive in nature, especially because throughout the shelter proceeding and all the way up until January 6th at that last shelter hearing, Maya Kowalski's mother was behind the scenes and had limited and very structured contact. The allegations by the plaintiff is that the hospital exceeded the scope of those orders and engaged in behaviors that were untoward, behaviors that are alleged to have been false imprisonment, battery, etc. The case has a sad ending in that Beata Kowalski, Maya's mother, took her own life on January 7th of 2017, and that is the resulting act for which a lot of these claims rest, or on which a lot of these claims rest. I apologize for the very, very awkward recap of where we are today, but I do that recap so that people that are coming in, tuning in live, know what we're talking about and that they know the subject matter of the case itself is sensitive in nature. Because of that fact, I have been running a banner throughout these streams that just alerts people as they come in that the subject matter we're discussing here is of a sensitive nature involving children, treatment, and allegations of words that I can't say on YouTube that frequently without getting the channel and the video taken down. But this trial is remarkably informative and it's important, so I want people to hear it. I want people to hear it. I want people to learn from it. And the information that I give and the context that I give is that of an attorney. That leads me to the next point. Why are we listening to the guy on the screen? The guy on the screen, me, Rob, hi, nice to meet you. Very nice to meet all of you. I am a practicing domestic relations attorney. I have been so for more than a decade, and I practice in the area of domestic relations litigation, divorce, custody, visitation, child removal proceedings, etc. So I have extensive involvement with Department of Children and Families up here in Virginia. We call it CPS, Child Protective Services. And that's the context that I bring to this case. So without further ado, well, you know what? I wanted to do one thing. There's a creator on the YouTubes with whom I have a great friendship. And this creator has hair that happens to be my favorite color, purple. And I asked that creator's permission because, as you guys are aware, there's been a very active jury asking several questions in this case. And that particular creator, I reached out to her and said, may I borrow one of your catchphrases for the introduction to the jury questions? She said, of course you can. Thank you for asking, my friend. And I'm going to go ahead and preview this now. We'll get to hear more of it later. Promise. But this is the new bumper, in case she's tuning in and sees, the new bumper for the jury questions.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
There we go. There we go. A little levity to start the stream. A little levity to start the stream. And for those of you wondering what the heck that was, what did we pan to? What was that in the background, Rob? My gosh, I've never seen that thing before. You haven't, unless you've been following the channel for a period of time. So that there, for those of you not understanding where we're going here, is the channel Law and Lumber. I am a attorney, but I do woodworking as kind of a passion project. That's what keeps me sane during the coverage of a lot of these cases. And one of the things that I say repeatedly on my channel is go make something, you'll feel better. The act of making, the act of building, the act of doing something, whether it's artwork, writing, painting, drawing, woodworking, metalworking, crocheting, stitching, I don't care what it is. The act of making something is cathartic. It is helpful. It is it has remarkable benefits to you and your mental health. And I engage in that and encourage in that. I encourage that repeatedly. What we see here is the jury. So everything that you're seeing on screen was gifted by a channel participant, subscriber, etc. And this is the jury of my peers. This is the jury that sits behind me in the background. What you guys see when you're on a live stream, you're wondering, what are those things in the background? This is the jury. This is some of the other creators in the LawTube sphere, people who create legal content and commentary. You guys might notice some familiar faces, such as Uncivil Law on the top, Richard Hogue, his wife, David from Prototopics, Emily D. Baker with the questions on the front of her little robot, Ian Runkle sitting next to Emily. Then you've got Law Talk with Mike. You have Joe Neerman. You have Boss Attorney Bree, the Shop Bot, the Chat Bot, which is that little starry bot with a computer face on it. That's you guys. That's the chat. And then the Shop Bot up front. That's me in the shop. So I figured I would share that with you guys. And this is an opportunity for me to share that and explain what that is so that we can avoid a lot of the questions that end up coming up during these live streams. Bring the jury. I think we should do it again.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
Oh, I love it. That's fun. It's a quick little stitch. I put that together after work. Yes, after work, I put that together. So let's go ahead and get into the beginning of our recap. I promised you guys yesterday that what I would do was begin with the testimony that we heard at the end of, what was it, 2 days, or days now weeks, or weeks now months? Is that where we are right now? It would have been Tuesday. Tuesday is what I'm bringing back. So Tuesday, we had 2 depositions that were conducted, and I did not get an opportunity to comment on those. It was late in the evening, and I didn't want to give short shrift to those because I thought they were favorable to the defense. And I want to be fair and even-handed in my analysis. So because I didn't want to cut them short and cut that analysis short, I saved that for today, and I promised you guys I would lead off with that, and that's where we're going to start today's proceeding. So I'm going to go ahead and reduce my volume to about 58% because StreamYard likes to blow the eardrums off of everyone who's listening, especially when I'm doing court coverage. Court coverage is remarkably quiet. This is gained up 600%. 600%. I can't make it any louder. I can turn my volume down, but I can't make it any louder. There is no closed captioning on this particular stream. I apologize for those that wanted it, but I couldn't pull it up today. And let me go ahead and do this because we also have swoops when we go between content and we go from transitions of intro to substantive testimony. God, I love this. This is the fun part of life. Fun part of being an attorney. Here we go.
Yourselves, you did no investigation and did not receive any information. Is that correct? And have you been approached by anyone about this case? And have you seen any media accounts about this case? Okay. Now, I did receive a note from one of your numbers that reads, during videos, is it okay to stand up to avoid drowsiness? I will tell you this, whether it's during a deposition or if it's somebody on TV, if you would like to stand up and stretch for any reason, you are free to do that. So just go ahead and do it now. If you're in the front row and you're standing up, just kind of make sure you're not running into somebody and try not to block their views. Okay? You okay with that? Yes. Now, as far as the lighting is concerned, do you want me to turn on the tray light above you? The only thing is I don't have any control over dimming that. So that's the real bright one. So I can turn on, I think, this center light. You like it how it is? Okay. Leave it. No lullabies, right? Okay. Defense, call your next witness, please.
We call advanced registered nurse practitioner Bonnie Rice, also by video you are.
Ms. Rice, will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give today be the truth, the whole truth, and nothing but the truth?
I do.
Bonnie, okay. Well, I'll keep it more, Ms. Rice, or Dr. Rice. So can you please state your name and professional title for the record, please?
Sure. My name is Bonnie Rice, Bonnie, last name Rice, and my professional title is nurse practitioner.
So you were there when that rule change came into effect?
I think that, I'm not sure if it was right as I left town and retired.
All right. Well, would you please give me the benefit of your training and experience in the field of being a nurse practitioner, starting from where you went to college, all the way through any training and professional licenses that you obtained?
Oh, well, let's see. I started as a diet aide in a hospital in 1973, and I worked in some healthcare capacity since that time. I rode ambulance for 4 years as a volunteer. I was a nurse aide while I went through nursing school. I got my RN in 1983 from Harrisburg Area Community College. I received a bachelor's degree in nursing in 1996, and I got I also had a minor in biology, and I had a master's degree in 1999, and then I finished my doctorate at Case Western Reserve in 2013. As and I still have active licenses in California as both an ARNP and as a nurse, and maintain my family nurse practitioner certification, but I am not going to be working anymore.
So my understanding is the highest level of professional licensure you obtained was the Doctor of Nursing.
Doctorate of Nursing Practice, it's known as a DNP. So when you're an ARNP, you can finish your doctorate, and that gives you a DNP.
Can you talk to me a little bit about your experience as a pediatric rehabilitation NP?
Okay, so when I initially came to the rehab program, I had about, 12 years experience, but I had pediatric experience starting in 1991, and I was certified at that time in pediatric critical care. When I came to Tampa General, I realized that was somewhat of a new position, so I obtained a certification in rehab nursing to make sure that my knowledge level was documented regarding rehabilitative medicine in children.
So what kind of courses or hands-on training did you do in order to get this pediatric rehabilitation licensure?
It's not really a license, it's a certification. And basically Dr. Kornberg, I made rounds with him every single day, doing the exams. When you're working as an ARNP for a physician or for the hospital, but you're primarily responsible to one physician, you follow their practice patterns, you learn their rules because you're very much an extension of them. How
long did you work with Dr. Kornberg?
12 years.
What else do you recall, independent of anything you may have reviewed about the hospitalization?
It was I think rehab is very much about this multidisciplinary team. And I have to say that this was a frustrating case for the team. That's what I remember.
And why was it a frustrating case for the team?
Because even though Maya was making functional progress, I didn't feel that we had gotten through to the family or that we'd helped the family. And I just felt like the mother and the daughter, they just weren't open.
What do you mean by that?
Every day when I would make rounds, part of my responsibility is to educate on to make families aware of what the child's deficits are and what the potential issues could be and how we may compensate for that. And then towards the end of the admission, if there's something that we can't compensate for, we want them to accept that the child may have an ongoing special need. Yeah, and I just felt like I couldn't move this family at all.
What do you mean I couldn't move this family?
I couldn't move them down their road of recovery, which is a road that, being a nurse, I kind of help patients through that road of recovery, and we do long-term follow-up. So we stay with these families even after they're discharged to make sure they get reintegrated to school, they have the appropriate equipment in the house, they have appropriate transportation, all that type of thing. So it's sort of like not a medical admission where we're working up medical things. We can do that, but as a rule, we didn't. We tried to move the patient from being a patient to being a child in society, back in the community.
Let me ask you this. Do you have any experience back when you were at Tampa General with treating children that are diagnosed with complex regional pain syndrome?
Yes.
Can you just generally describe what your experience with complex regional pain syndromes was back when you were working at TGH?
I think we had 1 or 2 children in the 12 years I was there that came in with complex regional pain syndrome. And really, I looked to Dr. Kornberg to lead the medical part of it, but it's where you have unexplained pain in one area or another that we can't find a physiologic cause for, or sometimes there could have been a cause and it's just pain that lasts longer than normal. right? That would fall outside of the normal pattern.
Did you ever, while at TGH, in connection with a complex regional pain syndrome patient, ever do what's known as a ketamine coma at Tampa General?
No.
Do you know what a ketamine coma is?
Yes.
To your understanding, what is it?
It's an infusion of ketamine. But, I have to tell you that for my time at Tampa General, ketamine was a very tightly controlled drug and wasn't even allowed to be used on the floor where we were. And I know that
All right, so let's get some people caught up to speed. Yes, I have to go back and review Dr. Posey. I'll get that in a second because I skipped this one. It's out of order. But here's the thing. We're doing this chronologically. The defense has decided they're going to lay their case out chronologically, which makes sense for the defense. The defense's position is that Maya came into their care, the hospital. They came into J. Hatch's care with these pre-existing issues. And not only that, but the reported allegations by the defense of obstinance, of the insistence of ketamine, this in the defense's case is being attributed to, well, the family having pushed this. And this is being brought on to demonstrate that the issue that J. Hatch had before them wasn't just a brand new case. It was a case that existed before. This was a family. This was Maya Kowalski who existed before this, who pushed ketamine at previous instances. You have here the nurse who's basically saying we couldn't even use ketamine on our floor. I have no reason to dispute that. This, as we have heard throughout the testimony, the use of ketamine in the treatment of CRPS wasn't commonly done. So hospitals have policies as to what drugs they can administer in different departments. So I don't see any problem with this testimony itself. And it was smart by the defense to bring this up. I thought both Rice and Posey yesterday, or on Tuesday rather, were great witnesses for the defense. They do a great job of giving context to that initial admission. We get to the initial admission in today's testimony.
they were using ketamine now in a number of different ways, but it's all new since 2015.
Are you familiar with the doctor Anthony Kirkpatrick? He used to be on staff at Tampa General. Do you know who that is?
I don't recognize the name.
It has been suggested in a blog entry by Maya Kowalski that you were practicing witchcraft on Maya Kowalski at Tampa General Hospital. Were you practicing witchcraft in connection with Maya Kowalski?
No, I'm not a witch, and I don't practice witchcraft. I don't even believe in witchcraft. I'm a scientist.
Understood. And it's fair to say that you were using evidence-based practices in your treatment of Maya Kowalski?
But isn't science witchcraft? That was a joke, a poorly timed joke. I get it.
Absolutely. The only thing that we had that was, it was a consult to integrative medicine. We did have a team there at Tampa General that would do things like Reiki massage, aromatherapy. We did some disability yoga, breathing exercises. So we had consulted them just to see if they could help with Maya's complaints of pain.
Can you please describe what your independent recollection is?
Okay. So, like I said, my job was kind of to be that holistic person and lead them down. Usually, it's a road of grief, of accepting that maybe their child was in an accident, maybe other people were killed or whatever. So we're on this sort of grief and coping road together.
Do you have any personal animosity towards Mrs. Kowalski?
Absolutely not. I tried to connect with her in every way I could think. And our joke in rehab was we'll try 1,000 different things to get kids moving again. And I think Dr. McCain and I talked about this mom almost every day because I felt like I couldn't connect and I couldn't sway her perception of reality.
What do you mean by perception of reality?
She was hyper-focused on medical tests and treatments. And the team felt that the child's problems had a very heavy psychological and psychiatric overlay.
Okay, what is a history and physical?
A history and physical, when the patient first comes in, you want to find out, you have usually records from the referring hospital. We were a referral service, so people referred into us. You have some records from the referring hospital, and then you go in and question both. I admitted the family as a unit. They're our discharge plan. They're how this kid's going to go home, and we've all got to, cope together and move forward. And they needed to learn what they needed to learn and be able to cope with that. And so I would start right away trying to form a relationship with the child, the family. And I remember this kid came in with her father, and he was a very good historian. He had medical background too.
You recall what his medical background was?
Something in first responder, EMT, paramedic, firefighter, something.
Who was the referring physician for this hospitalization?
It was Dr. Hart. We worked very closely with him.
Okay, and Dr. Hart, I think you said is a pediatric physiatrist over at All Children's Hospital?
All Children's, yes.
Okay. And what was the estimated stay for this hospitalization, as best you can tell from the H&P?
Oh, heavens. We estimated 4 to 6 weeks.
Okay. And is that where it says ELOS, estimated 4 to 6 weeks?
Yes, and so because we're a functional admission, these children would not be in the hospital if they weren't there to make functional gains, as a rule. Not always, but as a rule. So, you can sign out at any time. It's not like a regular hospitalization. We're helping you to walk and take care of yourself and go to the bathroom on your own and feed yourself. And if there's a mental disability or a speech issue or slowing issue, we would get speech involved. And so you can sign out at any time. And so we want to make sure that the family understands what our length of stays might look like. However, this occurs before the 48 hours of evaluation that occurs by the therapy team. In that first 48 hours, everybody on the team sees this child, evaluates the child from their perspective. So each person would evaluate the child from their perspective, and then we'd bring it back and change the plan of care accordingly.
What's your recollection of any discussions that you had with Dr. Kornberg about this patient?
We talked on a daily basis. I let him know that from my holistic standpoint, in terms of her, the mother and the child, that I felt we weren't connecting. We weren't being therapeutic. There was just a wall there.
What was Dr. Kornberg's position on this?
Okay, let's fast forward a little bit here because we do have to get through a lot. So you hear that there's difficulty in the patient care already. Let's go to 819. We'll go here.
Help, right?
Yeah, so I don't think she was happy about it, but she agreed.
And what did you see after mom left for a bit?
Things normalized. It just seemed like mother-child were in some kind of a battle of the wills. That's just what it seemed like every time we went in. And so when the mother was not there, that wasn't present, and the therapy could continue.
Do you agree or disagree with Mrs. Kowalski's contention that Maya was doing better when her mother was present?
I disagree.
Why do you disagree?
From observation and correlation.
What was Dr. Vijapura's position on this?
Well, so Dr. Vijapura is a psychiatrist, right? So he doesn't, I mean, he's a medical doctor, but his...
I was interested as to how this made it in. This is a bit of this is hearsay. This is asking about the position of another doctor. This was probably objected to, but it did make it in. Oh no, I lost my place. What did I do? Rob. We are professionals. There we go.
How things would be different.
Here it indicates.
I disagree.
Why do you disagree?
From observation and correlation.
What was Dr. Vijapura's position on this?
Well, so Dr. Vijapura is a psychiatrist, right? So he doesn't, I mean, he's a medical doctor, but his concern was not her function per se. His concern was what's going on from a psychiatric standpoint. So it was a little bit different.
Did he think that with mom not being around?
He asked mom to give us a couple days to see how things would be different.
Here it indicates that Maya had some complaints of blurry vision. Do you have any recollection of Maya's complaints of blurry vision about 20 days into this hospitalization?
Yes. So once her mother left, she seemed to do better. But when her mother returned, she had a number of complaints. And one of them was that she had, her mother had observed an eye twitch and she had reported blurry vision in her right eye.
What steps?
Sure it was the right eye.
Can you please explain what you were describing there in your note, ma'am?
Yeah, so, once we had worked with her for a while, the exams were just so inconsistent. Muscle improvement occurs in a specific way. And you can't, there isn't any disorder that I know of where you can be absolutely normal 1 minute and then completely disabled the next. And that's what we were seeing.
That's the part I think the jury took. That part. I wanted to get there. I think from this witness, I agreed this witness was remarkably, I thought she was credible. She did a very good job. And she was very favorable witness for the hospital. She's not affiliated with JHatch. She's Tampa General. So there's no incentive for her to say one thing or the other. She just had a different take. But when she went to this road here, when she went to, there's no condition that I'm aware of where one patient can be in no pain 1 minute and extreme pain the next. That's one of the problems with CRPS. From my knowledge, from this trial and from past experience, that is not CRPS. Like CRPS is basically that can come in at onset in a second. You can be completely normal and then all of a sudden your leg's on fire or your arm's on fire. So that was the part from what I received of this, knowing how the jury's been asking questions so far, based on the prior testimony, the jury is viewing that skeptically.
All the time. It wasn't this progression of this muscle getting stronger, or this muscle getting a little weaker. It was this absolute change in function from a very low functional independence measure to a very high functional independence measure, depending on the situation.
Now, later on in this note, under psychiatry, it says recommended reducing parental presence to see if this affects mind's progress. Is that a reference to what we were talking about earlier about not having mom room in?
Yes, and that's why I had Dr. Vijapura tell her, because I felt like I said, she didn't really recognize any expertise on my part, and that's okay. That's okay. But I thought if somebody was a doctor and sat down with her, and specifically in what we thought the problem was with this child, maybe he could break free to her.
Let me ask you this: you've had a chance to review the 820.
Can we stop the playing and approach?
A little back and forth. Where was it? I pulled this one up because I wanted to. Step, good comment. This woman treated Maya before CRPS diagnosis. The Kowalskis were still searching for answers. What I got from her testimony was the rehab and TGH were compassionate, honest, and working with the family. They were trying to work and they were trying to find a solution. But again, the hospital is putting in the record the things that existed prior to her admission to Johns Hopkins, and also showing how. Let's take this logically for a second. If I appear and report that I have a diagnosis, right, that self-reporting, and it's something the hospital considers, and the hospital begins treatment with that self-report diagnosis. That's what they do. I go and I say, I have this ailment. I give my medical history, and the hospital is saying, this is the medical history that we have. We operate based on that. Let's take that off of the table for a second. Just 1 second. If a child is appearing with acute pain or pain all over their body, or pain that's limited to a region, the hospital is in diagnostic mode and in therapeutic mode. What they're doing is they're trying to assess how to best treat this child and what possible diagnoses might exist. This, if it predates the CRPS, what this is testimony to bolster Jay Hatch's conclusion that if they didn't look at CRPS, if they kind of viewed the self-report with skepticism, what would they go through? How would they approach the beginnings of treatment? So I thought this was effective on the part of the defense. I don't know if the jury bought it, but I thought it was effective. This would be how I would approach the case the same way. Let's go to Dr. Posey and see if we can't get some of her, because I apologize. I bypassed that one pretty quickly. Let's see. Here's Dr. Posey.
Okay,
Let's go back to the
we came back
viewing
before,
screen.
So we're about an hour and 20 minutes. Do you have something really short, or is?
We have 2 video depositions. One runs about 50 minutes and one runs about an hour 10.
So you heard that. Do you want to take a break now? Do you want to do the 50-minute one now?
It's a 50-minute one, so we're not going to go through all of it. Spinny wheel. Stop. Behave. Internet strong. Internet strong. You can do this. Internet.
Tell us who you are calling, and I'll.
Which one's the shorter of the two? Hold on,
Well, that's okay. I'm trying to figure out the lights.
How much? Okay, then we will be calling Dr. Bahar-Posey as our next witness by video.
Yes, you may. Just make sure that.
All right, here begins the video deposition.
Would you raise your hand, please? Do you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
All right, doctor, you're currently employed at Johns Hopkins Ultraman Hospital,
Yes, I am.
and you worked there in the fall of 2016.
Yes, I do.
And just to orient the jury, you understand we're here to ask you questions today about the care and treatment of Maya Kowalski by Johns Hopkins Ultraman Hospital and yourself.
Yes.
Okay. Exhibit 3 will be plaintiffs 04069 through plaintiffs 04077. It's a 9-page physician note.
Okay.
You have that in front of you, doctor?
Yeah. And you want to make that 3?
Yes, sir. All right. Doctor, in front of you is what appears to be your note from October 7th, 2016. Do you agree?
Correct.
And did you review this ahead of today's deposition?
Yes, I did.
Okay. And is this a true and accurate record of your observations from October 7th, 2016?
Yes.
And it reflects your medical decision making on that October morning?
Yes.
Okay. And you're duty bound by the hospital to keep accurate, complete records. Is that correct?
Yes.
And your code of ethics and duty towards the patient requires the same. Is that right? I'm sorry. Page 6 of 9, it's plaintiffs 4074. And on that page, about 2/3 of the way down, you see medical decision making and then entry for differential diagnosis.
Mm-hmm. Yes.
I want to spend a few minutes unpacking that entry for differential diagnosis. First, could you please explain to the jury what a differential diagnosis is?
Differential diagnosis is a list of things that you consider when you're, after getting your history and examining a patient as to what might be going on with the patient.
Okay.
It can be a complete list. There may be things missing. It depends on whether you can think of every possible explanation or not. But usually it's a broad list of what could be going on with the patient.
But as you just testified, you're required to keep a complete and accurate record of your thinking on that day. Is that correct?
Yes.
So this note would reflect your medical decision making on October 7, 2016.
Yes.
When do you conduct a differential diagnosis?
After getting a history and examining the patient.
Do you do this with all patients?
For the most part.
For any simple case, you would also do a differential diagnosis?
Yes.
So let's talk about what you listed there in your differential diagnosis. I'd like to go through each of these in turn and understand what you were thinking at that point. So the first condition you listed was withdrawal.
Correct.
Can you explain what you were thinking?
The child had received ketamine, and from the history that I had obtained, it appeared on more than one occasion. So the presentation of the
So what she's doing is she's working through the diagnosis. What she's doing is she's trying to narrow down, like just take from the field of diagnoses that are available for this particular child in this ailment. We are narrowing down this list and trying to exclude things and then keep a list of things that are the likely diagnosis.
child, and the symptoms could be explained by a child going through withdrawal from ketamine.
What did you understand at that point about how much ketamine Maya had been administered?
I didn't have a good idea of the total volume that she had received in the past. All I had was the information that Dad gave me when she presented.
And do you recall what that was?
Yes, that she had been placed in a coma at some point in Mexico, receiving ketamine for a prolonged period of time, and that she had continued to receive it, I don't know how many times, and that she had just received a dose the day before presentation.
As what?
That she had just received it the day before presentation to the emergency department.
Were you made aware, or basically review the records, did you understand that other than the day prior, what the previous administration of ketamine, when that would have occurred?
No, I did not know.
Okay. You talked about dependence on ketamine. Are you talking about physical or psychological dependence?
Both.
And would you please describe the physical dependence symptoms of ketamine?
I prefer not to go into that right now because I don't have a complete information on that, so I don't want to give you the wrong information.
But you generally understood on October 7, 2016.
She doesn't do that because this is something that's been testified to repeatedly. And from what I've gained from a lot of the information from the doctors and even J. Hatch's doctors, when they get pushed on this issue of physical dependence and physical withdrawal symptoms, they all actually concede that ketamine itself, and again, not medical advice. This is me recapping testimony. The testimony that I have heard so far in this trial, both from J. Hatch and from the plaintiffs, is that ketamine, while it does not exhibit physically addictive properties such as opiates, which are physically addicting, where your body physically addicts it. It's physically addictive. That ketamine itself is more in the terms of what I would call an abusable drug, a drug that is abusable, psychologically addictive. It is the effects that you gain from that experience, the effect that you gain from the pain relief can become in your mind a psychological dependency. You depend on it. And you can go through with psychological withdrawals from being weaned off or removed from that. Now, she doesn't go in through the physical dependency. She says, I would prefer not to talk about that. And Creed, no, I don't give legal advice on this channel either. Because honestly, I'm just giving commentary. Legal advice, talk to a lawyer in your jurisdiction about your issue. Okay. She doesn't go into the physical dependency issue because I think that this is a bit of a misstep. She wants to dance. She wants to walk this fine line of physical dependency and psychological dependency. And there are physical ramifications to the abusability of this drug or to the dependency that one might develop a psychological need for it. But as far as the actual properties of the drug itself, I think the consensus that I have from the witnesses prior to this and after this is that it doesn't have a physical dependent characteristic to it. I might be wrong, but I'm just saying what I'm recalling from the testimony.
And that physical dependence was a possibility.
Yes.
From usage of ketamine. And what source would you have gone to verify that?
I didn't need to go to a source at that point. It was just something that I was considering.
Did you confer with anyone inside the hospital?
I spoke with anesthesia.
Who did you speak with anesthesia?
I don't remember.
And that's not reflected in your record?
I did document that I spoke with anesthesia.
Can you please point me to where you documented that you spoke with anesthesia?
It says, I discussed the dosage with anesthesia and at the second line from the bottom.
And withdrawal was one of those. you didn't have strong confidence that was not the case, but you listed it because it was a possibility. Is that right?
Yes, I did.
What is RSD for the benefit of the jury?
It's reflex sympathetic dystrophy. It's known by other names, like chronic regional pain syndrome.
Okay. And why did you list that in your differential diagnosis?
I told you I'm not crazy. I know that people call it chronic regional. So that was a mistranscription. The transcription says complex regional pain syndrome, but what she says was chronic. I told you I didn't just screw that up myself. I know that it gets referred to as both.
That was what the father claimed that the child had.
Constipation. Why did you list that in your differential diagnosis?
The father told me that she had a history of constipation. She had just been seen in the emergency department for constipation. So it was in the list, and she was presenting with abdominal pain.
You also listed other intra-abdominal issue. Would you please explain that entry?
Well, the father told me that she had been seen in the emergency department for abdominal pain. So there are multiple other causes of abdominal pain that have to be considered in any child that comes in with abdominal pain, especially when they were just in the hospital for the same reason.
So that was again based on the father's representation?
Yes. And the fact that the complaint was still persisting.
UTI, for the benefit of the jury, what is UTI?
Urinary tract infection.
Okay. Why did you list that?
Because that can cause abdominal pain.
Okay. That was not based on the father's representation. That was based on your medical opinions, all right?
It was something that you have to consider in any female with abdominal pain.
Okay. And then your last potential diagnosis there is psychogenic. Would you please explain that for the benefit of the jury?
Psychogenic is another thing that has to be considered with any child that presents with abdominal pain.
Would you
This is the part the defense wants.
elaborate on that term for the jury, please?
Psychogenic would be any kind of mental health problem that can present with signs and symptoms of abdominal pain. For example, depression, anxiety, conversion disorder. There's a whole list of these.
Sure. So you're referring to psychological conditions of Maya, the psychogenic entry there?
Psychogenic is something that you have to consider in a child that presents with abdominal pain.
Right. And when you can list
Unless
that,
we're almost there.
Various psychiatric diagnoses of Maya, is that correct?
I was not aware that she has any psychiatric diagnoses.
You were considering psychiatric diagnoses of Maya, is that correct?
Yes, that would be something to consider.
Okay. So next I'd like to turn to page 8 of 9 here. So plaintiff's 04076. On that page, the third way down, we see impression, diagnosis. Now, this reflects your opinion following the differential diagnosis. Is that correct?
This is the working diagnosis when
No. Internet be strong. Internet is strong. Why are you misbehaving? Don't do this to me. I will be upset.
Impression in this diagnosis rendered after the differential diagnosis or before the differential diagnosis?
this is written, it's written after the differential diagnosis, but it doesn't mean that that's the diagnosis.
It plainly states diagnosis reflex sympathetic dystrophy. So would you please explain to me how that's not the diagnosis?
We oftentimes in the emergency department document a diagnosis that later on turns out not to be the correct diagnosis. You have to write a diagnosis when you're admitting the patient. At the point when the child presented, this was all I had, and therefore that's all I could write.
Well, you refined your opinion based on the differential diagnosis. Is that correct?
Because I could not rule all of these things in the emergency department. There is no way that I can rule all of these in or out in the emergency department.
And why not list other potential diagnoses here under your impression?
Because it wouldn't have changed anything.
This was credible to me. This was very credible to me. She is in the emergency department. She is making on the fly diagnostic decisions. I have no problem with any of her train of thought here. How she went through the GI tract, how she went through urinary tract infection. I have no problem with that. All of this sounds very reasonable given the fact that she is in the emergency department. So this is ER. This is very different than like a complex diagnostic evaluation. This is an ER treating physician.
As far as her management.
So a later provider reading this note would not understand that the diagnosis is RSD?
No, a later person that would look at this would see that that was the diagnosis that I admitted the patient with. Does not mean it's correct. It doesn't mean it's incorrect.
Okay, but it was your best opinion at the time, is that correct?
No, as I said, you cannot rule all of these diagnoses in or out in the emergency department. That was the working diagnoses that I admitted the patient with.
Who establishes the working diagnosis?
I do.
Okay, why list RSD over one of the other 5 conditions that you listed on a differential diagnosis?
Because I couldn't rule them in or
Okay, there you go. That was what the plaintiffs wanted kept in. So you have the defense, who you can see elements of this transcript that are cut up, where you have the plaintiffs picking pieces of it and the defense picking other pieces of it. the plaintiffs, the defense wanted in a lot of the analysis and a lot of the fact that you had a lot of these other things that still were in that pool of diagnoses that were potential diagnoses. The plaintiffs want in that this doctor independently evaluated and diagnosed RSD. That's what the plaintiffs wanted. That the criterion with which Maya presented, how she presented, allowed the doctors, just with her presenting, to determine that diagnosis by themselves, independently of what was said when they walked into the door. That's what the plaintiffs wanted in.
Or out, and it was the diagnosis that the parents claimed that the child had when the child arrived to the emergency department.
This was the only diagnosis you could rule in.
I couldn't rule it in. It was the working diagnosis. It's what the child presented to the hospital.
Oh, Whitney, I like what you tried to do there. She said, I like what you tried to do in the deposition. Very good. I like what you tried to do. She just said that, like, she's working on a system where there's a pool of diagnoses and she tries to rule out certain of them. And Whitney goes, well, this is the only one you could rule in. She goes, no. I work on this. I can only weed things out. I can't rule something in. I can weed things out.
Saying that they had.
Did she present to the hospital with constipation?
Not to my knowledge.
Did she present to the hospital with abdominal pain?
Yes, she did.
Why not list abdominal pain on the diagnosis?
I could have put that there, but I didn't.
So you rendered some sort of decision, and the outcome is reflex of the dystrophy. Is that correct?
Again, it's a working diagnosis. It's not something that I could rule in or out in the emergency department.
All right. What I don't see listed here is Munchausen by proxy.
Psychogenic, I think it's in the DSM for psychogenic.
When we just discussed this, you stated that those were psychological diagnoses of Maya that you were considering. Is that correct?
Psychogenic was one of them.
Right. And psychogenic referred to psychological diagnoses of Maya, correct?
Yes.
Right. Not psychological diagnosis of Beata. Is that correct?
This is illegal. This is a
A lot
trap.
of psychogenic problems in children are caused by their parents.
Okay. So your testimony is that your psychogenic
Application.
categorization there includes the potential for Munchausen by proxy.
It's in the DSM.
Okay.
For psychiatric problems.
And is that something that you were actively considering
Yes.
in the admitter, Munchausen by proxy?
Yes.
Okay. So upon suspecting Munchausen by proxy, you then turned to the Johns Hopkins Children's Hospital protocol for addressing suspected cases of Munchausen by proxy. Is that correct?
No,
Why not?
we don't have a protocol.
You don't have a protocol.
Not in the emergency department.
The hospital doesn't have a Munchausen by proxy protocol.
We do not have a pathway or a protocol in the emergency department.
How long have you been at Johns Hopkins Children's Hospital by the fall of 2016?
10 years.
All right. You previously, additionally, in 1998, gave a presentation at the first national conference on Munchausen syndrome by proxy. Is that correct?
I did.
Okay. And so at that time, you were aware of the literature out there.
The literature at that time, yes.
Okay. So you did not make that diagnosis on that day.
You don't make that diagnosis based on one emergency room visit.
Okay. So as you admitted Maya into the patient intensive care unit, you did that, correct?
Sorry?
She was admitted into the patient intensive care, pediatric intensive care unit?
Yes.
Okay. Who did you discuss her case with?
Dr. Laura Bose.
Dr. Bose. Okay. What did you relay about Maya's condition?
I relayed to her the child's.
Okay, we need to fast forward a little bit here to get to the next part of this. 702:42, we start talking about the medicines. Cora, I see your super chat. I'm going to pull it up in 1 second. Thank you for the very, 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 very generous super chat.
Aware.
Aware. If you were going to seek an outside opinion on a pediatric CRPS case, who would you go to in the state of Florida?
I don't have a specific name because I've not needed to. I usually refer to TGH. There's a CRPS clinic there, but I don't know the names of the people who went there.
Your testimony was you did not consult with anyone outside of the hospital other than Dr. Hannah's staff. Is that correct?
Outside the hospital, no. I contacted the pain management physician who was giving that kind of dosage to her in order to clarify exactly what the child was receiving.
And you're referring to Dr. Hannah's staff, correct?
Yes.
And they confirmed that they had previously provided her on the day prior 1,500 milligrams. Is that correct?
Well, actually, I think the dose was 1,250 milligrams with 50 milligrams of 2% lidocaine, 1,750 milligrams of max sulfate, and 4 milligrams of Versed.
Okay. So Beata's request wasn't out of line with the previous day's dosage, was it?
It was actually higher. It was 1,500.
Right. Is it? How much higher is that?
250 milligrams.
Is that significant?
In a child who weighs 30 kilos, yes.
Had Beata asked for 1,250 milligrams, would you have felt that was not an absurd request?
You have to understand that the dose, the way that we give ketamine in the emergency department is different than the way she receives it in the pain management clinic.
Okay.
In the emergency department, we give it in a bolus form. So we push.
Okay.
Okay. Pain management gives it as an infusion, as a continuous infusion over hours.
Okay.
Okay. We don't have the nursing or the staff to monitor a child for that period of time in the emergency department. Nurses are not allowed to give ketamine in the state of Florida in the emergency department. Okay. So giving her
That I did not know. These are all very good points. That I did not know. These are all very good points. She was restricted as far as what she could give in terms of ketamine. And what she's testifying to is the insistence of mom in the face of that restriction to administer the ketamine. Her restriction was, I think she could give like 0.5 grams or something like that per kilo of weight. I forget the exact thing, but it was so significantly lower, much lower than the infusion realm, that she said it was absurd. And what it is there's different methods of administering it. There's different methods of monitoring it. And she's explaining this. So this is there for the hospital to basically say, I have these restrictions. I can't do these things. And they don't have the staff, training, capability of doing it. Yet what she's testifying to is that mom was obstinate in response to that. So regardless of what your opinions on her, this is credible to me. This is good testimony for the defense.
her 1,500 milligrams as a bolus is absurd.
Okay. The decision to admit Maya was made due to this staffing concern and inability to administer the ketamine dose as requested?
Among other things, yes.
Okay, please detail the other things.
The fact that she would need to be monitored, the fact that she needed a pain management specialist to be supervising this, as well as the ICU.
Okay. Who did you speak with in the hospital in pain management?
I spoke with the anesthesiologist who was on call. And then he was going to, or she, I don't remember, was going to talk to the pain management group. I can read it to you if you want.
That'd be fine.
It says, I discussed the dosage with anesthesia, who stated that they would, it says given, but it's give more if needed after discussion with the pain management doctors and evaluation of patient on the floor.
Can you give us 3 names that you deal with most often in anesthesiology?
Dr. Elliott. I think it's Dr. Patel. And there's Dr. Drozanin.
Can you spell that, if not?
Drozhinin.
Okay. Those are the anesthesiologists you confer with most regularly?
Those are usually the people on call when I call to speak to somebody.
Okay. So the decision to, I'll make sure we get this right. The decision to admit Maya into the intensive care unit was due to a concern about the inability in the ER to administer ketamine via infusion.
Correct.
And your understanding was, after talking with Dr. Vos and whoever you spoke with in anesthesia, that they would further consider whether that dosage was appropriate.
They would further consider the management of pain in this child.
Okay.
Not necessarily specifically as it related to the dosage, but to control the child's pain in an adequate fashion.
Okay. And so Beata's concern was controlling Maya's pain. Is that correct?
Her concern was that I comply with the dosage of ketamine and that I actually give her the medication that she felt was necessary for the treatment of her child at that time.
And when you explained to her that you'd have to admit her to the intensive care unit for that to be administered, did she resist that?
She initially wanted me to get anesthesia to come to the emergency department, but I was unable to do so. And after I told her that it would have to be in the ICU and that I was not willing to give any further doses of ketamine, then she complied with that.
Okay. So she was in a bit of a rush to have ketamine administered.
I wouldn't necessarily agree with the wording in a rush. I think she definitely wanted to push her opinion of how this child's pain should be managed immediately.
Okay. That's essentially what I gained from that witness. And she's credible AF. I mean, yes, she's resistant. She doesn't like being cross-examined. I understand that part. That doesn't bother me at all. I've been in courtrooms enough that I can tell when witnesses you're not having to pull teeth out of her. She's giving you the answers. And a lot of them make a lot of sense logically when you think about how the hospital works as far as the emergency department, what they're allowed to do there on emergent circumstances versus what they can do as a full hospital with pain care management. This is also the only person that I have seen so far who, when learning of the ketamine infusion, what I think was favorable to the plaintiffs is this witness testifies that she called Dr. Hannah's office to confirm the dosage. She actually called Dr. Hannah's office. She's the only one that I've seen so far that actually did that so far. I think this was a very credible witness. The testimony to the ketamine, the use of ketamine, and honestly, it's Beata's conduct in how she portrays the conduct if I'm in the jury, I can imagine a distraught mother who, having dealt with the pain, the chronic pain syndrome, having dealt with this, rather the chronic pain itself, the CRPS, the complex regional pain syndrome, for a period of time leading up to this, would be insisting on a certain course of treatment. I can see that. I can hear this. I can feel this. This is something I can imagine taking place, and I don't have to make giant leaps of logic to get there. So there's things in this testimony that are favorable to plaintiffs, but by and large, this was a favorable witness for the defense. So that's what I wanted to kind of recap here. I thought she was credible. I thought she was one of the strongest witnesses that we've heard for the defense. Honestly, I think she's the only strong witness we've heard for the defense so far, if I'm being honest. No, the nurse was good too for the defense, but this was the first one who really gave me a lot of the information that, well, a lot of the background that I've been wanting to hear. So, I mean, you guys might disagree with it. That's fine. And I don't, the explanation to mom, I understand that part. I understand a lot of these parts. You guys can disagree. I'm completely fine with that. I am just saying from what I took, and I knew you guys would disagree. Excuse me. I knew that you would disagree when we got here. I knew you would. I knew you would. But I told you I was going to call the balls and strikes as I saw them. I know you're going to disagree. I know there are opinions in the chat. There are people who agree with me, people who disagree. There's nothing I'm going to say that's going to make anybody happy here. But that's not what this is about. This is about me giving my interpretation of how effective that witness was. The questions being asked, they did a good job with that witness. That was a good witness. It was a good witness for the defense. She was combative a little bit, but not more than I would have expected from an adverse party. So I want to call out a couple of these super chats because there was a lot that were there, and we've gathered a lot. And I apologize. The chat is moving so fast, and I have so much to cover in a very short period of time. As you can tell, I am still sick, so I can't do a 4-hour stream that I wish I could. You guys know that I wish I could. I've shown you I can. I can do 6, 7, 8 hours of a stream, but I can't do that tonight because I have to recover. I actually have a meeting tomorrow morning at 10 a.m. So I need to be able to be alive and functional for that meeting. But I do want to call out chats as they come in. Cora Savage, thank you for the very, very generous super chat. I was in the hospital 1 month with pneumonia pleurisy. As a kid in the hospital, everything is big, scary, and it hurts. I was told, quote, this won't hurt, end quote. It all hurt. My parents were there the whole time. I lost it. I can't imagine what Maya went through. I am so not impartial. Cora, I want to tell you right now, that is 1,000% okay. It is 1,000% okay for people to enter into this proceeding, enter into these determinations with a position or a thought. People refer to the term bias as if it's something terrible. Bias isn't something terrible. Bias is just the way I've described this before. People always say you need to detach from your biases and that this witness is biased. Bias is the desire for an outcome. That's all it is. You have a desire for an outcome, whether it's a gut desire or a logical desire, you have a desire for an outcome. And you view every bit of information that you receive with that desire for that outcome in mind. So that desired outcome is swayed one way or the other based on the information that we process. It's not bad to have a bias. It's not bad to not be impartial. These aren't bad things. You guys are allowed to do that. What I ask people to do is to momentarily take those biases and that experience that you had in your life. And I don't mean to set it aside, but what I mean is that take a moment and try to view it through a different lens, because there's education to be had. There's learning to be had in setting aside momentarily certain predispositions or desired outcomes that we might have in mind. If anything, what it does is it helps understand the other side so that when we go and approach and give our argument, we can do that more effectively. Cora, I'm really sorry for your experience. I'm sorry this is a tough trial for you to watch. I hope that, this is a learning experience for everyone in the chat, yourself included. I'm not rooting for one side or the other. I will say that the lawyers in this case have been interesting characters to follow. I will say that I have emotions that I try my best to hide in a lot of these things because it alters the legal analysis that I'm giving you. Thank you for the very generous super chat and for the contribution to the chat and discussion along the way. It's very, very much appreciated. Cheryl, thank you for the generous super chat. Karen, does the jury know that Maya's CRPS was confirmed after she left the hospital? It feels like the hospital still doesn't want to think she has CRPS. You're going to hear a lot from today's testimony about the hospital and working diagnosis of Munchausen by proxy. You're going to hear that. And I think the hospital is sticking with its position. You have a lot of doctors that are testifying, and the testimony, the working testimony, makes it feel like they still don't believe the CRPS is real. Quit gingery. I wonder if they told mom no ketamine or no ketamine. We aren't able to provide it here like that. They simply told her no without explanation. I can see why she was upset and kept pushing. I can too. And this is about interpersonal dynamics. And what I also want to stress here is how we can give grace to people that are in positions of stress. How many times a day does an ER nurse get abused by a patient? How many times? I know I have ER nurses that are friends of mine, and the stories, the comments, what they go through on a daily basis and what the doctors go through on a daily basis is remarkably taxing. Does that excuse them from treating every person with the level of care and compassion that they should treat everybody? No, it's not an excuse, but it is something that explains behavior. I want the best out of people all of the time. Unfortunately, the profession that I am in, I am dealing with people that are dealing with the worst parts of their life, the worst moments of their life. And because of that, sometimes they make bad decisions. They act impulsively. They say things out of line. They say things that are coarse or caustic. So when we hear about the interactions between Beata and these nurses, there are two sides to that. Yes, there's the mother who is frustrated that her child is in pain. There's also the nurse who has been through so much that day. There's the doctor who's been through so much that day. So I want people to give grace to both sides of this equation to the extent we're talking about that type of dynamic. Solo YOLO. Rob, how are you? RN here. This testimony is 50-50. I think so too. I think it did well. Matt Bond, good to see you here, my friend. Testify. We will move hell and earth for what works. Okay. Lynn 2574, but she didn't work for Jay Hatch. Her calling shows what the other doctor should have done. That was what I thought was favorable for the plaintiff when I made the comment about the call. Della, Jules should call in to the show each day for tidbits. Jules and I chat behind the scenes. She's observing from inside the courtroom, and I don't want to take away from what she's doing. I don't want to distract from what she's doing in there, because what she's doing is observing. She has an opportunity to do something that so few people do, which is watch a trial from start to finish from inside the ropes. I try to give you a glimpse, but she's there in person. Just Sarah, do you think Laporte mentioned Hopkins yesterday because that's all she knew about Maya's interests, or to plant the seed that she interrupted on the call since the voice mentioned them? I don't know. That's a good question. I wonder if the jury thought that too. Jenkins, hey, Rob, just playing catch up. The B. Rice statement you point out ends in depending on the situation. Were there any follow-up questions on that? There were. I can't replay everything. I really wish I could. I am at time constraints. I'm going to make a comment in a minute that's going to give you guys a little, if you want to go and watch some of the YouTube stuff live. Israel, me being strangled was psychogenic for 6 years. I'm sorry that you went through that. That's tough. These misdiagnoses have impacts. Gabby, even if the hospital calls lots of competent J Hatch people that the jury thinks acted reasonably, could any of the plaintiff's claims be won on Kathy Beatty related to evidence alone if J Hatch can't disprove them? That's an interesting question, because I think that that's a possibility. The doctors could have been reasonable in every single fashion in reaching the diagnosis in these different decisions, and there are still claims that are out there that are in the realm of outrageous conduct by the hospital. So a lot of the diagnosticians, the people that are making the determination, this evidence is relevant. but it's not the crux of the case. It's not the turning point of the case. The hospital knows that too. They're putting these preliminary witnesses on because they know that the big elements of the case are yet to come. They want to end on that. So they want to build the jury's trust little by little, because the trust has been taken away by the plaintiff. The plaintiff presented an effective case that deprived the hospital of any trust by the jury. The jury has no trust in the hospital right now. The hospital needs to work methodically to rebuild that trust before they start trying to insert larger witnesses. It makes sense. You guys remember what I was telling you about telling a story. When you are presenting a case, you're telling a story. And the story only makes sense if you tell it in a certain order. The hospital right now can't put on any big witnesses to testify to the photographing incident, the EEG incident, because if they were to try to do that right now, the jury would have zero ability. I know personally, think about this. You've watched this case for so long. If you were in that jury box and someone from the hospital came in and said they tried to justify the behavior of the photographs, you'd be like, not listen to you. But if you heard a little bit of the regaining of the trust when they brought that witness on, maybe you'd look at them differently. I don't know, but that's the tactic the hospital has to go by. That's what they have to do. They have to rebuild the jury's trust at this point. Jessica, thank you. I need to know why the opposing side often goes first when playing depositions in court. Help, because just how the cookie crumbles. It's the information they want to get. What happens is the favorable witnesses for the hospital are adverse witnesses to the plaintiff. Okay. So when I'm the plaintiff in a case and I'm suing the hospital, all of their doctors are adverse to me. They don't want to talk to me. So what do I have to do to get them to testify? I have to depose them. So I send them a subpoena. I make them sit for a deposition. I'm the one that calls them to stand. I call them. I make them testify. That deposition is recorded. But the hospital, they know that's a favorable witness. If they can get the information out of that deposition without putting that witness on the stand and subjecting that witness to cross on the stand in front of the jury, they're going to do that because that's smart, right? So it's an adverse witness to me, but if the information that's taken out of that deposition is favorable to the hospital and they can trim it down and put it in front of the jury without risking cross-examination, they're going to do it. It's a good call. It's sound strategy. So that's part of the answer of why the hospital, and when you listen to the plaintiff's deposition designations, you heard a lot of the hospital attorneys asking questions. Brandy Rose, followed you since before you posted the deathbed video. Your coverage of this case has made my decision to become a member. Thank you. This case is so important. I appreciate your dedication. I appreciate you, Brandy, and everyone that's here watching. This trial is delicate. It is delicate. It is walking a tightrope as far as what is okay to say and not okay to say. I have tried to be careful with what I say in response or in commenting on this trial because of the sensitivity of the issues we're discussing. And I appreciate all of you for tuning in. I really do. Very much so. Sarika, member for 12 months. Happy 12-month anniversary. Happy 1-year anniversary. And thank you for gifting memberships on the 1-year anniversary of that. It's very kind of you, very generous. Anna, YTD's defense witness talk about pain was infuriating. Had back pain. Hospital docs saw me 3 years, 0 results, said I exaggerated. This is something I've heard as a repeating thing here. And honestly, I have learned so much in this trial about how many people out there are afflicted with chronic pain. And like I said, this has been a learning experience for me, and I have taken that to heart. And I appreciate the hell out of every one of you who are in the chat commenting and teaching me and helping me learn this. This trial is teaching so many others about people who have chronic pain and not to dismiss them just because you can't see it. I have friends with chronic pain. My Canadian elf friend has chronic pain in his back. And this is teaching me a lot about that. So Tilly M. Lopes, this trial is happening coincidentally during a pain flare-up for me. I'm very sorry for that, Tilly. Just found crochet. I'm very arts and craftsy and actually helping my pain make something. That makes me feel better. Becca, no, it's this jury. We have our jury. We love, yes, bring this jury, bring this jury, bring this jury, bring this jury, Bring this jury. Morgan, thank you. Maya could have been just as successful in where she is today if her mom was there. Not assume that she's better because her mom is gone. That's a horrible defense. And why aren't they saying that? They will. There's some technical reasons why they can't. The suicide is a claim, is surviving by a thread. If that claim goes away, they cannot make that argument on closing, because it would unduly influence the jury to make a verdict or a return of a verdict on a false imprisonment claim with damages that well exceed what it would have been for false imprisonment. Like I said yesterday, and please go back to that stream. That's where I give the explanation of the suicide count and how that is hanging on by a thread and why it's so important in this particular case. Bravo, Chick. Hey, Rob, new viewer. Thank you for covering this important case. Future paralegal here. Congratulations. One thing I can't figure out, why was Kyle allowed to stay with the parents if CPS suspected child abuse? Because it was medical child abuse, and it was about the victim that CPS identified. It's a very close caveat, but I can see your point. But the hospital identified Maya as being the victim here, which required additional attention there. Baby steps. RN here. Thank you for the respect to the medical community. It's a tough job. Most people are good people, but not all. That's true. It's very true. Thank you, baby steps. LJ Peach is a parent of special needs child who was an ED frequent flyer who had to deal with different ED docs. I had to carry written orders from her pediatric neurologist, because they wouldn't listen to me. I believe that. I believe that emphatically. Okay, so let's get to today's testimony, today's proceedings, and we begin with some, well,
This is case number 2018 CA 5321, Johns Hopkins All Children's Hospital versus, Jack Kowalski, et cetera, et al. Versus Johns Hopkins All Children's Hospital. Let's take appearances starting with the plaintiff, please.
Greg Anderson, Nick Whitney on behalf of the plaintiffs. Sorry,
Maybe Ms. Lawrence should be the one introducing everybody.
Howard Hunter, Jack Rowell, Johns Hopkins All Children's Hospital.
Just for everyone's planning purposes, I have meetings at lunch today, Friday, Monday. So each of those 3 days that I know of right now will have to end right before noon.
Your
We're
Honor,
talking about exhibits, right?
yes, but before we do exhibits, the defense would like to move for reconsideration of the court's ruling yesterday, allotting 4 additional hours to each side. The basis of the motion is the prejudice that's going to result in the defense. And to lay this out, the defense has respected what this court's admin.
hang on, coughing spell. I missed 2 things. Rewind, Rob. Rewind, Rob. Baby steps, thank you for your first super chat ever. Thank you for participating. Thank you for talking. Thank you for sharing. The chat welcomes it. I welcome it. I love it. Thank you. Wait, continue rewinding, Rob. First, swoop. Second, play. Come on. Judge. Come on, Judge. Let's go. We're waiting. I know it's a replay, but we're waiting. Judge.
Please be seated, everybody. This is case number 2018 CA 5321, Johns Hopkins All Children's Hospital versus, Jack Kowalski, et cetera, et al. Versus Johns Hopkins All Children's Hospital. Let's take appearances starting with the plaintiff, please.
Greg Anderson, Nick Whitney on behalf of the plaintiffs. I'm sorry,
Maybe Ms. Lawrence should be the one introducing everybody.
I agree. Miss Lawrence, who just passed the bar. Miss Lawrence, tomorrow, may it please the court, I want to hear you introduce people. That would be a blessing to me. I would love seeing that. Put that young lady up front. She just passed the bar. She's been sworn in. They just recognized her. Let's let her make the appearances. Good morning, Your Honor. Ms. Lawrence here with my colleagues, Greg Anderson and Mr. Whitney, for the plaintiffs. Can we do that? That would be awesome. That would be great. Talk about a sunshine moment. Wow. Good for you, Judge Carroll. Good for you, Judge Carroll.
Howard Hunter, Jack Crowell, Mr. Bureau, David Hughes, and all that. John Hopkins also.
Just for everyone's planning purposes, I have meetings at lunch today, Friday, Monday. So each of those 3 days that I know of right now will have to end right before noon.
Your Honor,
We're talking about exhibits, right?
Yes, but before.
Seems quiet. Hang on. Are you gained up to full volume? No, you're not. You're quiet. Now you are.
We do exhibits. The defense would like to move for reconsideration of the court's ruling yesterday, allowing 4 additional hours to each side. The basis of the motion is the prejudice that's going to result in the defense. And to lay this out, the defense has respected what this court's admonition has been for the weeks leading up to trial, that each side was going to have 55 hours that would include direct, cross, and rebuttal. The court made it very clear to both parties, in fairness to this court, that that was also going to include a division of jury questions. And to the great credit of this court gave the shot clock every single day to both sides.
Oh, unfortunate pause. Sorry, Mr. Shapiro.
But where we were,
that's still
so there would be
unfortunate.
no surprises.
Better. Hang on.
The defense, in reliance on that, did their best. We did our best to give expedited cross-examinations, including a relatively brief cross-examination of Dr. Duncan, who had 4 reports with underlying assessments, a relatively briefer cross-examination of the economist, who had multiple reports, a relatively brief cross-examination of Dr. Bifolco, who had 2 different reports and also had categories for each relating to different illnesses that I intentionally expedited to save ourselves time on direct for the witnesses we needed. We cut down our cross-examination of Dr. Chopra, including not going deep into his credentials, even though he misrepresented his connections to Harvard. We shortened our cross-examination of Dr. Kirkpatrick, and even when our case began, we cut down several designations of Bonnie Rice in order to make sure we had enough time. The plaintiff was well aware of the shot clock, and instead of resting when the court was looking at them to rest, they continued to call witnesses that we believe to be extraneous to their case, including multiple people from the church, Facebook friends with no real relation to this case, and at the end of their case before resting, a relative of the Kowalskis who testified through a Polish language translator. They made their strategic decisions on the order, and only after they rested did they ask for additional time. While we appreciate that the court allotted additional time to both.
There we go. That's not that bad of a pause. Mr. Shapiro, that's not that bad of a pause. You might take issue with that. I got you in a not bad moment. You're making a point. It's a good point. So the point Mr. Shapiro is making right here, Judge, you granted extra time. You granted 4 hours to both sides, and it was after the plaintiffs rested their case. We managed our time appropriately. They did not. Therefore, we are being punished because we could have used the additional time you're giving in additional cross-examination that we did not get. Now, the caveat here is the judge's explanation is rock solid. It's rock solid on this case because of one important fact, the jury. A lot of the questions that are taking place in this courtroom right now are the jury's making. They are the jury's questions. The jury is not only just making questions themselves, they are essentially opening up the door for cross-examination or additional questions by both parties. This is something that I don't think any judge could have anticipated. The judge himself makes a comment about how observant and interactive this particular jury is. I have never seen, even in cases where juries are allowed to ask questions that I've observed, I have never, ever seen anything like this. This is a jury that is quite literally a freaking lawyer. As a party, they are a lawyer. I've never seen it. So I don't know that you can anticipate this. Plus, the judge does give it out equally, which means that Mr. Shapiro can call these adverse witnesses in a case in chief, which actually could make it more impactful, being that it's more recent in time to when the jury actually deliberates. Mr. Shapiro here could be using that 4 hours, for example, that additional 4 hours of time. He could take that 4 hours of time in the hospital's case in chief and call each one of those witnesses he's identifying and cross the living hell out of them right before the case goes to rebuttal, where the plaintiffs have limited time. Mr. Anderson, speed up your case, my friend. Speed up your cross. I know you're trying. Speed it up. I'll make more comments about that later. I was screaming at the monitors. But, Mr. Shapiro, we're going to listen to the rest of your argument.
Both sides. The prejudice of the defense is we cannot go back and recreate cross. The net effect of this is the plaintiff has 4 additional hours to cross-examine witnesses that the defense doesn't have. And due to that prejudice, we would ask the court to reconsider its ruling and go back to the 55 hours per side. Thank you.
The court's going to deny the reconsideration. Certainly, the court has been. Can you sit down now?
It took a half a second. I missed that part. I had tried to catch that part, but I missed it. I have to play it again. Hang on. I'm sorry, Mr. Shapiro. I'm not making fun of you, my friend. This one is one the judge he knew you were going to say it, and he was like, I know I'm going to rule. He knew how he was going to rule the second you started
The
talking.
prejudice of the defense is we cannot go back and recreate cross. The net effect of this is that plaintiff has 4 additional hours to cross-examine witnesses that the defense doesn't have. And due to that prejudice, we would ask the court to reconsider its ruling and go back to the 55 hours per side.
If
Thank
the
you.
court's going to deny the reconsideration, certainly the court has been, can you sit down now? The court has been,
Oh God, Mr. Shapiro, I've been there. I have been there, my friend. I have been there, my friend. It is not fun. I do not like it. It is painful. I hate that feeling. With the judge, you knew how he was going to rule. You did, and you did what you had to do for your client. You jumped on the sword. Good for you, sir. Good for you for making the motion you had to make. You had to make that to preserve it on appeal. Good for you. And you have to do the next step too, apparently. But I don't know if you want to, and not this way.
very cognizant of the time issues. To the credit of this jury has been extremely active in asking questions, which of course has generated additional questions from both sides. I think it's appropriate at this time. I hear what you're saying. If you wish to call Dr. Duncan and some of these other folks to ask them additional questions, you were free to do it because you also got an additional 4 hours defense. So, I don't see it as any sort of prejudice. I think it's appropriate given the length of time of those jury questions. And that's my decision. What's next?
And Your Honor, just briefly, because I do need to perfect the record on this.
You've already spent 5 minutes talking on this issue. And the whole point coming early was to talk about exhibits.
I'll merely note that we have to move from this trial time to time decisions are rendered, so the defense moves from this trial.
I have been here. I have been here in this uncomfortable moment. I hate these feelings. I hate this feeling. I hate this feeling. I feel for Mr. Shapiro. I really feel for Mr. Shapiro right now because I have been here. It sucks. You have to tell the judge. You have to tell the judge, Judge, I respect your ruling. I have to do this. In certain cases where a judge overrules an objection that I have, and it's an important objection. Hang on, let me go a little bit bigger for this. Where the judge overrules an objection that I have, that it's an important objection, I need to note it for the record. And the judge overrules it on muddy grounds, or where the party asks the exact same question again. So the judge overrules the objection, right? And the witness is then instructed to answer. But instead of just answering the question, the other party asks it again. I am required, the appellate court requires that I preserve that objection, which means if I allow it to go asked again unopposed, I could be viewed as waiving that objection, which means that I have to be the jackass that stands up again and says, Your Honor, I have to preserve the objection for the record. And the judge looks at me with that tone of voice that we just heard and just Ms. Morton, sit down. Judge, I know that you're mad at this. I have to preserve the record. What I have to do sometimes is where the judge overrules an objection on an evidentiary rule, but he doesn't make it clear why he's overruling the objection. I have to stand up and I actually have to preserve the record. I'm required to, ethically required to do this. I have to stand up and say, am I to understand the court has overruled my objection because the court has found that it is not hearsay? The look that you get from across the bench is one that makes you. This is why, like, you need a certain amount of experience to be in a courtroom like this at this level, because the look you get will shake you and it will scare you from doing it again. But you have to. You have to realize at that moment, the judge has to play his role. He has to respect the fact that you have to play yours. So I made that point because when I heard it, I was like, this sucks. This sucks. This is really hard, but okay.
You're moving for a mistrial. I just want to make sure I understand. You're moving for a mistrial when you got additional time and you can call the same witnesses to address whatever issues. Is that what you're saying?
Yes, Your Honor.
Because we don't. Can go ahead, please.
Denied.
Judge, we clearly want to get some records into evidence. We have not received any specific additional objections. We just gave the court our There's no new exhibits listed. They're the ones we've been trying to get. So we would like to start with 3032,
3032.
Laurie Children's Hospital records.
And what's the objection?
Before this, Judge, you may recall, just on the motion for curative or
Can we
otherwise.
stick with exhibits? Like I said yesterday, I need to trim our sales. We need to stay on topic. Exhibits.
I understand, Judge.
Stella got her groove back. Stella got her groove back. Judge Carroll got his groove back. Judge Carroll is back to moving this case along, and God, I appreciate the hell out of it. Oh my gosh. Amazing. Let's go. Let's go.
This is designed to do exactly what you told us to do Tuesday morning. You ask us, because the difficulty of all of these individual piecemealing objections to hearsay within hearsay and experts that are not experts. We put together a curative instruction. And it's not even really that. It's a 301.5 evidence admitted for limited purpose. And the purpose was, we don't have to get into that. They can move these things in wholesale as long as there's an instruction so that the jury does not take a doctor or a nurse who may have random comments in the record and attribute to them as though they was on the top. I don't know if you it or not. I have a copy of it here.
I know what you're talking about.
Judge,
Approach.
Judge, they filed this late last night. We haven't filed a written response, but they want some overall arching curative instruction as opposed to doing what the court asked them to do, which was to identify which pages and sections of this record they object to.
So this was filed last night. I honestly don't think I've seen this. This hasn't been docketed yet. I wouldn't do that. No.
Yeah. Okay. So Judge, we've received no specific, we need to move the Larry Children's Hospital record then.
What's the objection?
Hearsay contains unqualified expert opinion, quasi-expert opinion. I think hearsay, mostly hearsay within hearsay.
Is there,
those comments may contain there and they're not for medical treatment.
the other day, you said that you had a list of documents that you were concerned about. Is there something specific, or is it just this generalized statement?
Judge, I think we were hoping to have some form of generalized objection based on that, or a curative instruction that would limit our only concerns, and then we wouldn't have to go through all of these. It's impossible over the course of the evening to go through every single one of them. We understand the court's position on this, and we'll set the court's ruling wherever it is.
The court's going to let in the medical records from lawyers, which is 3032. Is that pages 1 through 249? Is that the complete?
It is my understanding it's the complete record, Your Honor, 3032.
Okay. What's next?
3047 Tampa General Hospital 73015.
And that's 1 through 1148.
That's correct.
Anything specific about this, or just a generalized statement that you just made with respect to lawyers?
In particular, comment that Bonnie Rice contained within where she was, we can go through it, but we need 24 hours. If it could be admitted with the proviso that we'd be able to come back, we understand that our objection of hearsay within hearsay and unqualified expert opinion or opinion hearing the expert, then what we could do is come back because there are a number of quote opinions by Bonnie Rice, who's not a medical doctor and they're not to a regional medical probability nor could they.
I delayed from Tuesday when this issue was addressed to give you time, so I'm not going to further delay. So court will go ahead and receive 3047, the entirety, which apparently is 1,440.
Thank you. Going back to the first page, Judge, 3023.
Okay, I want to pause here, and I was typing something off screen because I wanted to show you guys what we're talking about here. Let me stop sharing this one, go back to the awkward big face, and then start sharing a different screen. What are we arguing about right now? We are arguing about medical notes. Oh my gosh, that is minuscule. There we go. Okay, so you need to get your life in order, you little chat box window. We can do this. So we are arguing about medical records and documents. Why are we arguing about this? Because here's the thing. These documents, these medical records will oftentimes contain reports by third parties, and that can be remarkably prejudicial. Because what you have right there is you have essentially the patient's medical file, and you can get that in over a hearsay objection. Hearsay being you are trying to introduce an out-of-court statement for the truth of the matter asserted. But hearsay has to be overcome at every level of hearsay, which means sometimes a report, while you can get it in as a business record and overcome the hearsay exception, sometimes that report will have something that is a third party statement outside of that business. That is also hearsay. And you have to try and get that in. So I just typed this up. This is something that I would imagine would be objectionable to the plaintiffs in this particular case. Plaintiff appears with a self-report of acute pain in abdomen, consulted with Dr. Rando, who advises that patient is diagnosed with MBP, Munchausen by proxy. I confirmed with patient the pain treatment plan to date, verified with treating PCP, primary care physician. Dr. Rando advises patient is full of shit and can't be trusted. So here's the thing. Yeah, I said Dr. Rando because this is something I typed, not a document here. But this is what would be objectionable in this context. That's why this fight is happening right now. This note is from my own words, guys. I just typed this thing. I told you. I just told you. I typed it. I just typed it. I typed it. It's not real. Hang on. I will clarify. I will type right now. This is not a real record or exhibit in this case. Clarify? It's an example. So this is objectionable to prove the point. Proving the point about why we're objecting to these documents coming in as one body of medical records. These medical records are replete. They are filled with different references to other people who are giving information. Same with a police report. Police reports are filled with third-party testimony, third-party notes, stuff like that. You're allowed to admit certain parts of the police report because the police officer or the medical provider that's performing the treatment is taking these notes in the ordinary course of business. This is their routine practice. Therefore, it is given a little bit of weight. So it overcomes the hearsay objection at that level. However, this part here, this little part here, consulted with Dr. Rando, who advises that patient is diagnosed with MBP. That is Dr. Rando's statement. That's Dr. Rando's statement. That is not the statement of the provider who is making the log or making the notes. So this is a second level of hearsay. You technically have to overcome this level of hearsay in order to get that particular statement in for the truth of that statement. I confirmed with the patient, and like, here's the thing. Some people are going to say, well, it's fine. They get that note in. But I left this last statement in here because I wanted to give you an example of what if the medical record said something like this. If the medical record said something like this, Dr. Rando advises that the patient is full of shit and can't be trusted. Well, that changes the game. That changes the math. That changes the importance of whether I allow this document in. So why am I making a point of this? This case has thousands of pages of medical records. Thousands. All of these medical records come in. Every single thing about her medical condition that is contemporaneous around the same time of treatment, because this is a medical malpractice case, every single one of those records is relevant. They all come in. You can object to hearsay within hearsay, and you can make that objection by drawing out what I did, pulling those little lines up. Boom, 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 boom. And the judge might rule on those. But this is an indication to me the plaintiffs are remarkably overwhelmed. They are trying to prepare their witnesses for the next day. They didn't just disregard the court's ruling because the court said, I will take these little hearsay snippets and I'll listen to you. You can present them to me. If you find something objectionable, you can present it to me. But the plaintiffs, when they reviewed the thousands of pages of documents, were like, I can't go through and highlight everything I need to remove. I have to prepare for trial the next day. They couldn't do it. So they came up with this, we want this blanket objection. Please give an instruction to disregard opinions within opinions. That doesn't work. It doesn't work. It's not fair. You can't tell the jury to disregard something as a whole, like piecemeal, because that tells the jury to give less weight to the document as a whole. It's not really, that's not how that works. It's not fair. It's not fair to the defense. So the judge makes the right call. The judge's like, look, I gave you time. I gave you 2 days to go back and look at the documents. If you're the plaintiff's counsel, I'm betting right now that you're kind of kicking yourself. You're going, damn it, we should have redacted. We should have had a redacted form of this. But again, I don't think this hurts that much because this was going to come in anyways. So, anyways, that was my explanation for what we're about to hear, the argument being made. And I wanted to give you guys context so that you guys understood what it is we're talking about and why these objections are failing. That's what I can add to this. I'm not a medical doctor. I can't do this, but I can give you guys trial understanding. I can tell you what's happening in court.
Is this the complete set?
That's my understanding.
Mr. Whitney, are you taking this one?
Yes, Your Honor. We do have specific objections within this record.
There you go. This one's important. What I just said, this one's important. Out of all of those files, out of all of those voluminous documents, it's not Mr. Anderson making the general. Mr. Whitney's going, yes, we have specific objections to this one. They knew this one was important, and they knew it would be. Good move, Mr. Whitney.
For hearsay within the record in 403, I can point the court to the pages. First is 3023 0003. If we can put it up. If you want, just turn it on. The screen's off.
Get the camera off, Maya, please. Get it off, Maya. Whitney's talking.
Yeah, it's over to his feed.
It's on. 3023. 3023. And then page. I'm sorry. 3023. Page 3.
Will you take the camera off her face and look?
Highlight the history of
Thank you.
Pull that up. Just larger, please. Your Honor, within this entry here, about 3/4 of the way down, the line begins, the pediatric intensive care unit because part of her home pain regimen consists of ketamine infusion. Our objection to this record is that this theme is throughout the Arnold Palmer record. This mistake, this inaccuracy. There was never a home pain regimen consisting of ketamine infusions. So with respect to this sentence, we would just redact home. It's true that her pain regimen consisted of ketamine infusions, but other than the resident at Arnold Palmer that got this wrong, there's no evidence in the record that these ketamine infusions ever occurred at the Kowalski home. So it would be highly prejudicial to allow these records in and allow them to carry this thing forward.
We have evidence in the notes, the personal notes that Mr. Kowalski authenticated on the stand where Mrs. Kowalski wrote she was giving IV ketamine at home through the course. We intend to admit that record. We have the doctor that will come and testify either by video or live to these notes. We also have evidence in Dr. Hannon's records that he had Mrs. Kowalski sign a contract to not put ketamine IV through the court. So these are absolutely, this is not a one-off. This is part of the theme. That is part of the defense theme. They were certainly welcome to call this witness.
Who is going to testify that there was actually
judges all over it?
Who is going to testify?
Dr. Brandon Alexander.
And
Dr. Brandon Alexander is the resident I'm referring to, that Arnold Palmer who had this one interaction and put this down in his record. He has no basis.
As a general statement, the question of ketamine infusion at home has been something that's been percolating for years. And every single time I try to get actual direct testimony, it always seems to be a hearsay basis for it. So unless and until there's actually someone that comes and testifies, I am thinking of a 403 issue because
Well, Judge, we can then.
What's a 403 issue? A 403 issue is the information that you're seeking to introduce, while it might be relevant, while you might overcome some baseline hearsay objections, is more prejudicial than it is probative. Means that it does more in harm than it does in good. That the prejudicial effect of allowing someone to hear this outweighs the actual benefit it does by any evidentiary standard. So that's the 403 issue. FRE 403, 401 is relevance. FRE 403. Yeah, 403 is relevance. It's prejudice and probative. Prejudice and probative. Not hearsay. It's not hearsay. It's the relevance argument, the relevance analysis. While it might be relevant, it does more harm than good.
Hold this back for now, this exhibit, and after the testimony, come in and revisit.
And Crowellis does a good job of saying, Nope. Don't make a ruling on this, because if you exclude it, I can't bring it back. I'm going to withhold this. I'm going to make my argument later.
But unless I get somebody who's going to come in and says this,
Okay, we
the
understand. Judge.
reference to home ketamine infusions is not coming in.
Well, we will not ask that this particular exhibit be admitted at this time.
What's that?
We would like to put in 3001 and maybe we should, I'm sorry, maybe we should start with 3002 since they're related. 3002, the consent for
Consent was already in.
No, Judge, I don't believe 3002 is in. The hospital records are in, but they wouldn't agree to this page of the hospital record.
This is more simple.
Is it just Mr. Kowalski's signature? I mean, what is?
This is the consent that they signed when they came into the hospital, Judge. It's part of the hospital records. Plaintiffs would not agree to be part of the joint exhibit of the hospital records.
Well, I have no problem, and the consent's going to come in, but where's the first page that I want to see? Why isn't this all together?
Well,
if we're talking about the consent, it's the paragraph that talks about diagnostic treatment.
Yeah, there it is. It's on 4 pages.
You can see that the volume of documents is already overwhelming them. The one horse, one rider is meant to streamline arguments so you don't have multiple people talking, but you can see why the judges are, well, rather why this can be impactful to either side. Shapiro's trying to tell Crowell's something. Crowell's something, and can't get the information in fast enough for her to make her argument.
it's on page 2, Judge. This is 4 pages.
Okay, so the
Sorry.
page is the signature page.
Can you go back to 1?
It's in reverse order, Judge, so it starts out, then it goes all the way down. Number 1 is the signature, which would be the last page. Sorry to play it.
Okay, so 3002 is the full record.
No, it goes to 4. Yes, it's the full record. It's 4 pages.
Betsy, 3 and 4, please.
Guys, to see in the chat, please, we're not going to call her Cruella. We're not going to do that. I know that it's funny to do it, but we're not going to do it. I think she's one of my favorites on the defense side. She is, honestly. I like the fact that she is very pointed with her evidentiary objections. She has a job to play. We're not going to disparage any attorneys in this. We're not going to. So no name calling, guys. No. So I have no problem with her.
It's because, and the reason it's backwards, Judge, is because the hospital, that's how they do the hospital records. They come in.
So you're telling me 3002, page 2 is in. So what's the objection to pages 1, 3, and 4?
This has to do with a release and the stretching of something that has absolutely nothing to do with our issues, which are the photographs and the 48 hours separation.
This is Mr. Kowalski's signature on
It is
an
correct.
admission document.
I believe so.
Yeah, this is relevant. It's coming in. So the court will receive the totality of 3002.
Your Honor, please note we would like at some point argument on the terms of this agreement, because those would be within the purview of the court as the construction of the contract and its applicability to these circumstances, given the fact that they're not medical
Johnson,
records.
I think I've said, if you're asking for a instruction as to the contract, that seems like a jury instruction, and your side can ask for a special jury instruction on it.
I understand.
3001.
What is this?
It's a notice of privacy practice referenced in the 10.7.16 consent.
And
it's 4 pages.
Can I see pages 2 through 4? Have we already seen this? It hasn't. I feel like this is already.
I don't know, Judge. They all look alike at this point. How about?
Okay, they object to every medical record beforehand. The judge gets frustrated because they keep objecting to records that are relevant, and they keep trying to make the same objection. The judge is like, let's get the jury in here. I'm going to keep you guys until the end of time. I'm going to keep you till the end of time. I'm going to extend, you will work until 6 p.m. every day, and I will bring you in on Saturdays and Sundays. I'm not wasting this jury's time. It was awesome. It was awesome. Go judge. I loved it. It was fantastic. Move your case along. We are moving this case along. Damn it. We are moving this case along. These records are coming in. They're relevant. Did you sign it? Yes, relevant. It's in. It was great. It was great. Let's get to the very end, maybe. Well, maybe very end. Here we go. We'll do this part. We got signatures and documents.
No. Yeah, so it talks about Kevin Cohen. You're okay now? Of course. Things like this, we've been spending a lot of time on the question of relevance of medical records of providers concurrent to the specific time frame. I'm just pointing it out that we spent a lot of time on that. The court receives 3038, pages 1 through 9.
All right, do you want to wait on the rest? Give the time or?
Let's do the one that's 11 pages, 3039, and then
Okay.
that'll probably be it. Next page. And next page. Next. The date says 2015. Okay, next. What's a different facility, right?
I think it's the exact same procedure and the exact same page we saw before about just brought it up in one place.
I don't know if this was in the other, a lot of these doctors' records have records from other doctors, they've been forwarded to them. I don't know if this specific one was in the previous one, Judge.
And okay, I think it's fine. Questions it in the Johns Hopkins records? I don't know. We'll see. Court receives 3039, pages 1 through 11.
All right.
Okay, anything else before we bring the story?
Just a matter of scheduling, Your Honor. I understand we're staying until 6 in the morning.
We're going to keep going through exhibits. Yeah. We're trimming our sales and our days are going to get longer.
We have 2 issues, but I think they can wait till the next break.
And I highly encourage, since I'm telling you, our days are going to get longer, that you all need to be better at communicating and not fighting every single issue. But if you want to, we will stay longer and longer. If we need to start coming in on Saturdays and Sundays, we're going to do that too. We're going to finish this case. Let's bring in the jury.
Yes, Judge. Yes. Yes. Put all the egos in check. Put all of the egos in check. We will stay longer. It will make you come in. Detention. Detention for all of you lawyers. Detention. You will appear for detention on Saturdays. We will review evidence and we will get the evidence in front of this jury because we are not going to let the jury suffer for your argumentative nature, you children. God, I loved it. Amazing. Detention for all of you. This is your last warning. It is your only warning. I will bring you in on Saturdays and you will have to argue this because we are finishing this case. Otherwise, no evidence for any of you. No evidence for you. No evidence for you. Behave. Oh. Do not make me pull this car over. I will pull this car over. I will make a screaming goat that it broke. Oh, God. It's fantastic. That was fantastic. Don't make me count to 3. You're at 1. 1, 2. Do you want to go for Saturdays and Sundays? Do you want to go for Saturdays and Sundays? Really? I'm almost at 3. 2.5. Okay. Now behave. You too. In the back seat. I know you hate your sister. I know you hate your brother. Stop. Stop it. Stop it. Oh, God bless. Let's get a little bit moving. Let's get to our witness. Come on. Why is jury taking so long?
Good morning. Please be seated. Were you able to enjoy that lovely weather yesterday?
Okay, so here's the thing. I have an analogy. This is the mother in church. This is the mother in church whose kids are acting up. This is the mother in church whose kids are acting up. and you're in church, so you're the mom, you can't, or dad, I don't care who you are, mom or dad, and the kids are acting up, they're going crazy, but you have to maintain outward appearances, and the kids are going nuts. You're going, you shut up, right now. I will take you outside. I will take you outside, and I will belt your bottom. Oh, praise Jesus. Hi. Thank you. Thank you. Yes, love. God is a wonderful day. I will take you outside and end you. Yes, it is wonderful. Hallelujah. Be hallelujah to all. This judge turns it on like it is magical. I love it. Wait till we get home. Just wait till we get home. Wait till we get home.
I'm glad. A little too cold for the beach, huh? Okay. I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and you received no information about this case. Is that correct? And that you have not been approached by anyone about this case. Is that correct? And you've not seen any media accounts of this case. Is that correct? Mr. Hunter.
Dr. Michelle Smith, please come and take the stand. Anderson, what are you doing?
I'm a critical care physician at Johns Hopkins All Children's Hospital.
It's mic problem.
Can you hear me now?
Yes.
Sorry, I don't usually speak very loud. I'll do better.
Okay, there you go. You said you're employed at Johns Hopkins All Children's Hospital?
Yes.
And what is your job at Johns Hopkins All Children's Hospital?
I'm a critical care physician.
Now, the jury has heard a lot about Dr. Sally Smith, you're Dr. Michelle Smith.
Correct.
What's the difference?
I'm a critical care physician, so I'm trained to provide care to children in an intensive care unit. And Dr. Sally Smith is a general pediatrician who also specializes in child abuse.
Okay. Now, would you give the jury the benefit of your background and training, please?
So I went to medical school at Georgetown University. I then did my general pediatric training at Children's Hospital of Los Angeles. I then went and did a pediatric critical care fellowship at Johns Hopkins Hospital in Baltimore.
Okay. And are you board certified?
I am board certified.
Okay. How long have you been at All Children's Hospital? And I'm going to ask you to break down its different iterations of All Children's and then Johns Hopkins All Children's.
Okay. So when I first started, it was All Children's Hospital, and I started in 2002. And I have been there since 2002 and went through the transition with the acquisition with Johns Hopkins Hospital in Baltimore.
Okay. And what is your primary role at Johns Hopkins All Children's Hospital today?
I'm a critical care physician.
Okay. Have you had occasion to contribute to the literature in your profession from time to time?
I have done mostly quality projects. I have presented at a conference most recently in Portugal on simulation use in the ICU for cardiac arrest.
Okay. And do you work purely in the so-called PICU?
I work both in the pediatric intensive care unit and in the cardiovascular intensive care unit.
Okay. Did there come a point in time at which you became involved in the care of Maya Kowalski?
Yes.
And when was that?
I believe that it was October 9th. It was a Monday. I took over the care on Monday.
Okay. And if that were to be October 10th,
It was the 10th. Okay.
would that comport with your recollection?
I believe so, yes.
Okay.
If that was Monday.
I'm going to ask our faithful tech folks to put up, did you bring your notes with you?
I did not bring my notes with me.
You did not?
I did not.
Would you put up 1001-78? This is an evidence, Your Honor, as part of the All Children's Hospital record. And I'll ask you to put, it's not the page I was looking for. Go to the next page. There we go. Okay. Let me ask you to take a quick look at what's on the screen before you and tell us whether this is a note of your taking over the care of Maya Kowalski on Monday morning, October 10th, 2016.
I don't see anything.
Is that your note?
I don't see anything.
Oh. No.
Your screen's not.
Oops.
Let's sign up.
There we go.
It's working now.
Okay.
Thank you.
Our assistant IT.
Many times.
Hang on 1 second. And Mike, if you're listening, you don't need to come right now.
Pretty sure. So you came in that Monday morning, October 10th. Tell us a little bit about what your routine is when you take over a patient's care on a Monday morning like this.
Okay, so it's not unusual for us to start a service on a Monday. And so typically we would contact the physician who was on service prior to us and we get signed out on all of our patients. So that usually would occur on a Sunday. So I spoke with Dr. Teppa on Sunday and she would review all the patients that would be on my team the following day and review, the current plan of action and prepare me for taking over on Monday.
Okay. And was it your understanding this patient had been admitted over the weekend?
Correct.
And you were taking over from Dr. Teppa Sanchez?
Yes.
So when you took over, when you came in and saw the patient on Monday morning, what did you do? What did your routine consist of? What did you do to assess this patient?
So our typical day starts with another handoff. So the person who's on call that evening in the hospital, the physician, provides a handoff to us. And so we meet and again, get a handoff on all the patients in the ICU, what occurred overnight, so that then I have all the information from my handoff from Dr. Teppa. So what she may have not included in that handoff that she was unaware of. And then we would move from that to another huddle where we have a multidisciplinary huddle that involves our charge nurse, our respiratory therapist, both medical team physicians, residents, sometimes a social worker. And we kind of get a feel for what the ICU is like that day. It's kind of obtaining a shared mental model so that we know what patients in the unit are sick, who's going out of the unit, who will be discharged, what type of admissions we'll be getting. And it really just kind of brings us all together so that we're all aware of all of what's going on in the unit. It's a large ICU, and so it's important for all of us to know all of the, goings in and out of the unit.
Okay. In this particular case, what did you learn about Ms. Kowalski that morning?
Objection.
Did you take a history regarding Maya Kowalski that morning?
We would, my first interaction with her would have been on rounds. And so after we finish our huddle, then we start rounding and we go through all of the patients on our team. And during that, the nurse would also give us another update of any issues that came up overnight. And then we would present all of the current data, including vital signs, laboratory studies, or anything that would be available for us to review. And at that point in time, we would interact with the family. Now, and let me just clarify with referring to my note.
Is there a particular part of your note you need to refer to, Doctor?
I was just looking to see whether or not where I discuss our discussions with the family.
Okay. Well, let me direct your attention to the paragraph at the bottom of the page you're looking at, I think it's 79. And it says social. Can I ask our support here to bring that paragraph up? And it continues over to the next page, so you can refresh your recollection of what's there.
I remember that. So I did meet with the father. One of the pieces that was signed out to me by Dr. Teppa was the family's interest in potentially being transferred to Nemours Children's Hospital. And they had reached out to their ICU physicians over at Nemours about a transfer. And so I spoke to father and I told him that I would reach out to them. And I did speak to an ICU physician at Nemours who had reviewed the information that they had been provided over the weekend. They had discussed it with their pain team. And at that point in time, they did not feel like she was a candidate to be transferred to their hospital. That Dr. Santana, who is their pain specialist, felt that this would—
Objection, hearsay.
It's not offered to prove the truth of the matter asserted, Your Honor. It's offered to prove what she was told. What did you learn, if anything, from Dr. Santana about what they wanted to do or not do at the time?
Objection, hearsay.
Your Honor, may we approach camera?
Let's go ahead and fast forward to some of her other stuff.
As a doctor, felt she was safe.
Oh, wait, I didn't want that.
In order to transfer, correct me if I'm wrong, there is not a single, and she was agreeable.
in reference to ketamine, it was a gradual wean in the ketamine where we were going down like
Good question. Was there a conversation, a telephone conference that occurred involving Mrs. Kowalski, yourself, and some folks from Nemours Children's Hospital?
Yes.
And who was on the phone to your knowledge?
Dr. Santana, Dr. Torres, and then also present in the room with me was the bedside nurse.
And what was Mrs. Kowalski told during that conversation?
Mrs. Kowalski told her story, and then Dr. Santana told her that she has a lot of experience with CRPS. She trained in Boston, and that was where she had learned her management and was reproducing that down in the Orlando area in her own clinic, and that she had very good success with treating patients with this diagnosis using physical therapy, occupational therapy, and cognitive behavioral therapy.
Was there an indication that this outpatient program would be available?
Yes, yes.
And did you have a discussion subsequently with Mrs. Kowalski about that program and about transferring her child to Nemours for this outpatient program?
I did. I actually was very encouraged after speaking with Dr. Santana and thought that she was very well educated, very well experienced, and had good success. So I was actually really optimistic and excited that we would be able to make the connection for the Kowalski family to get care there.
Did you have an impression regarding whether Mrs. Kowalski would agree to such an outpatient transfer?
Initially, yes, I thought that she would be interested in it. She expressed that she was interested in pursuing it.
Okay. Now, your note that we have up here, which we're going to publish to the jury when we finish this, your note seems to make reference to continuing to the next.
All right. So here's the note. I contacted Nemours and arranged for a phone conference with Dr. Torres. the chief of pediatric critical care at Nemours, and Dr. Santana, who is the director of the pain team and an anesthesiologist at Nemours. We had an extensive conversation. The mother reviewed Maya's case with the physicians. Dr. Santana then explained to the mother that she has a lot of experience with chronic pain and chronic regional pain syndrome. I told you it wasn't just complex. I told you people missed that. And she participated in successful clinic at Boston Children's, and she's recreating this experience at Nemours. She described the treatment involving physical and occupational therapy and cognitive therapy. So this is the cell. This is the cell to get the transfer done. She explained to Maya's mother that her professional opinion and her experience there is no indication for intrathecal infusion pumps, and that would not be of service. So this is the pump that induces the pain med right in the spine. Yada yada. Mother's questions were answered at the end of the visit. Myself, patient's bedside nurse discussed the conversation with mom. So that's the note.
Next day, is that correct?
I'm sorry, where are you referring?
Well, let me just ask this. When you left the hospital on October 11th, did you have any impression regarding whether or not this outpatient transfer would be workable?
Soon after our conversation with the physicians at Nemours, and my understanding that we were going to hope to get her there as an outpatient, the mom told me that she really wasn't interested in wanting an intrathecal pump and wanted to explore other places to have this. And I believe it was Cleveland Clinic that she thought that they could potentially be transferred to get an intrathecal pump.
And did you attempt to arrange that, or did you attempt to contact Cleveland?
I did not. I told her that we needed to have somebody to reach out to and put that kind of on her to let us know who to reach out to.
And then was the last day that you cared for Maya Kowalski on October the 12th?
Wednesday, yes.
Okay. And did
Hi,
you have any
Jules.
further
Thank you.
conversations with Mrs. Kowalski that day?
Thanks for being here.
I did have conversations with her. We, again, every morning we met with the pain team and we discussed what our plan for the day would be and how we would wean, progress with our weaning. And so we reviewed that with her and she agreed with our weaning plan. We also, at that point in time, the GI team had looked at Maya. They had also looked at the CT scan that had been done over the weekend, and they felt that because of those abdominal pain that she had presented with, that it was worth doing an endoscopy. They reviewed her records and did not feel she'd ever had any endoscopy performed. And so this was discussed with mom, and she agreed with having that, which was scheduled for Friday. She'd require a go lightly clean out in preparation to have the endoscopy on Friday.
And during this 3-day period that you were taking care of Maya Kowalski, was the pain team also involved in her care?
Every single day.
And what was the weaning plan? If you can describe that briefly. We'll hear from Dr. Elliott about that, but what was your perspective on it?
It was in reference to ketamine, it was a gradual wean in the ketamine where we were going down like 1 milligram per kilo a day. I think maybe towards the end it was a little bit faster. And then with the dexmedetomidine infusion, that's given to an IV. Clonidine is an oral medication that acts very similarly. And so we had transitioned her to a clonidine patch.
I need to go across. I was trying to find the timestamp. Sorry. 125 even. Took me a second.
Hold on.
No.
Did you ever have a conversation about that with Mrs. Kowalski?
No.
Thank you, Thank you, ma'am.
Thank you.
So here's my synopsis of Direct. She was honest, forthcoming, direct. She was personal to the jury. No bad points on how she testified. She did really well. Really well. There's nothing wrong with her testimony on Direct. I feel like this was a miscalculation on Anderson's part because it was such a change of pace. I wouldn't have gone after her like this, but she said things that you didn't want her to say. I get it. You can bring it out of her, not this way.
So you're aware then that the Kowalskis were told not 2 days prior that if they left, security would come and escort them back into the hospital and call the police. You were aware of that?
Bro. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Right out of the gate. Right out of the gate. The problem is if you can't land the knockout punch, if you're taking a first swing and it's a knockout punch, you better land it. You better land it. It took him a while to recover. It took him a while. And the thing is, he burned a ton of time trying to recover. He came out, here's the thing, he came out hot. He comes out hot, he swings with a knockout punch, and it doesn't get the witness on the ground. You have not gotten the knockdown. At that point in time, now you're sparring. How long are you going to spar? If you had come in sparring, that witness might have opened themselves up. You might have then seen an opportunity for the knockout punch. It might have been quicker. You might have been able to save time. You could have saved a lot of time. Anderson comes out really strong. And what it does is it puts the witness on a defensive very early. The witness is defensive immediately and starts being very protective with her answers. If he had come in gently, asked some questions, probed a little bit, made it feel like he wasn't immediately attacking her, she might have walked herself right into some of those knockout punches you want to deliver. You have only a certain amount of time left, sir. If you're coming in swinging with a knockout, land it. If you can't land it, do the methodical cross that I know you know how to do. Boom, 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 make your points. Because what he ends up doing here is he ends up getting her in a defensive position and then takes about 30 to 35 minutes to get back to his more important points. That's time the plaintiffs don't have. You're right, Sarah. He lands it at a later time. But at what cost? At what cost? They have a clock running. If you are going to spend 45 minutes to an hour on these witnesses, I told you guys at the beginning of the stream, these witnesses are to rebuild the jury's trust, right? They're not the impactful witnesses. These are not the mic drop witnesses that the defense has. Remember the plaintiff's case. There was a bunch of witnesses that were in the beginning that they gave information, they were important, they were impactful, but they weren't the most significant. What did the plaintiffs do? They waited till the very end to drop the bombs. That's when they did it, at the very end. They saved their powder. Listen to that advice, dear sir, because you have a limited amount of time to cross-examine each and every one of these witnesses, and you're spending too much on the early witnesses. You're going to run out of time. And here's the thing. Here's the worst case scenario for you, Mr. Anderson. Just me expressing a possible outcome here. Let's say hypothetically that you burn all of your cross time on all of these witnesses, and the defense decides on day, 33 or day 28 that they are going to call Sally Smith live. It's your one opportunity to cross Sally Smith live. It's your one chance. It's your one shot. Now, take a look at all those 35, 25, 15, 45-minute crosses that you did. And how many of those minutes you want back? How many do you want back for the chance at that witness? I can tell you my answer. All of them. All the minutes. Give me all the minutes back. Sir, you are good at cross. You are damn good at cross-examination. I am not faulting you that. Like Hunter comes in there aggressive AF. Shapiro goes in there sarcastically. You have a style. I just wish you would punch it up a bit. Make your points. Make your points and sit down. Because the last thing you want is to be sitting there with Sally Smith on the stand on direct examination, and you've got 5 minutes left on cross. Just saying. Just me, lowly attorney. Don't know a lot, but I do know this. The clock is ticking, and there was a lot of burn time.
that right?
No.
Nobody ever told you that?
I was told on Monday morning that they wanted to go out of the hospital and there was conversations in regards to leaving against medical advice.
AMA, right?
Correct.
And is it, to your knowledge, AMA a force of law? I mean, do doctors through AMA, are they able to retain people and hold people in their rooms just because they disagree with a diagnosis?
It's the same.
Right?
Yeah, Mr. Anderson, it's the same.
I'm gonna change. So what's the reason AMA?
I'm sorry, can you clarify that?
Against medical advice?
Against medical advice is AMA.
And doesn't that mean that you disagreed with the treatment that the non-Johns Hopkins doctors had for Maya?
I think you need to identify the doctors to which you refer.
Hannah, Kirkpatrick, Chopra, Wassenauer, Barr, Spiegel.
Can you rephrase the question, please? The
Yes.
beginning of it, not the names, but if you could please rephrase the beginning of the question.
Against medical advice talks about your medical advice. The Kowalskis disagreeing with your medical advice, right? And to that point, they had been counseled by multiple experts in CRPS, right?
Mhm.
You had no CRPS program at the hospital, did you?
Correct.
So you said that when you spoke to Beata, she was cooperative and knowledgeable, right?
Yes.
And you explained your plan about weaning off and the dosages, and she was agreeable, right?
Correct.
And throughout the entire conversation, she was polite, and although expressed her opinion, was acting fairly normally for a parent of a sick child. True?
She was polite to me. She did ask for therapies that were unusual for families to ask for, but she was always polite to me.
So isn't the reason that, not necessarily you, but the hospital were keeping them there, was that there was a belief that somehow Beata was a harm to her child? Isn't that true?
Overall.
So I think that there were red flags in her history.
I'm not talking about that, ma'am. I'm just asking you a simple question. Was the reason that you were keeping her there because you and other doctors feared what Beata Kowalski would do? Is that true?
That is not true.
So they could have left at any time without any problem. And Johns Hopkins would have let them just walk. Sorry. They could have left at any time with no problem. Is that right?
We have a process for against medical advice, and so we would have followed that process.
And what would that entail?
So when a family asks to leave against medical advice, we contact the nursing supervisor and we contact
This is important. This is important.
social work. We go and we talk to the family. We explain to them why we feel like it is not in the child's best interest to be discharged. And in this case, she's still on significant doses of sedation. And we would have that conversation. If we couldn't come to an agreement with the family, then if we felt that it was an unsafe situation, then we would contact the Department of Child and Family Services. But at no point in time would we restrain the family or force them to stay.
So it would be against your policy, for instance, to tell the Kowalskis that if they did try to leave, security would be called to keep them there.
If a child is under DCF custody, then I'm just explaining the
Mhm.
policy.
Go ahead, please.
If the patient is under a shelter, then we would call security.
Anderson is losing this battle. This is him losing this battle because she is explaining and doing so in a fashion that's not combative. Like this is, he went in for the knockout punch. And like I said, if you don't land it and you let him dance, it's a problem with a witness. She's credible AF right now. And she is explaining and said, I'm just explaining the policy. Mr. Anderson, let him explain. Let her explain. People can disagree. I can tell you right now. Okay, you guys can disagree with me. In my opinion, based on what I've seen here, this is not how Anderson saw this going. It's not how Anderson saw it going. Just like my spinning wheel. Spinning wheel.
Security, but we would not intervene. We would, if the family was leaving, we would call the Department of Child and Family Services.
But from October 7th, 2016 to October 13th, 2016, there was no DCF hold,
Correct.
was there?
Correct.
And so to your knowledge, did anybody ever go to the Kowalskis and say, remember when we told you that if you tried to walk off, we were going to have the guys from security come here and force you to stay?
I never said that to the family.
Okay. And your reason medically
Mhm.
was she needed to be weaned off of ketamine. Is that right?
She was on several medications that we were weaning her off of, yes.
What wasn't the primary one you were worried about, the ketamine?
We were worried about ketamine, but she also was on dexmedetomidine, which was also a different medication than she had been on before. We had not resolved the concerns of abdominal pain. And at that point in time, she was not eating and drinking enough to sustain her hydration level and was requiring IV fluids. And so we would not typically discharge a patient that we were uncertain of their ability to maintain their hydration status. And so typically we would discontinue our therapies and make sure that the patient was in a state where they would be able to maintain.
Let me tell you why he's losing this cross. That witness just gave a 20-second answer. That witness was just given the opportunity to give a 20-second narrative answer. That's how you know you're losing cross. Witness control. Oh, Dread Pirate Wesley, thank you. Love you too, bud. He trolls me. I love it. And he's a friend. He's a friend. Those are funny remarks.
Themselves without needing all these things that were being done in the hospital.
Anything else? Was it or was it not the ketamine that was one of your primary concerns?
I think that there was a concern of the ketamine as an outpatient, and that's why other people were involved. But my concern was what I was being faced with at that moment in time when I was taking care of Maya.
So now, how much experience do you have with ketamine infusion?
I have a lot of experience with ketamine infusion.
Okay. Are you an anesthesiologist?
I'm not an anesthesiologist.
Psychopharmacologist?
I'm sorry, repeat that?
Psychopharmacologist?
No.
Psychologist?
No.
Did you prescribe for Maya during this time, by the way, an antipsychotic? Haloperidol?
Haloperidol?
Yeah.
Haloperidol is an antipsychotic, and it was a recommendation that was provided by the pain team with mom in agreement.
So you wanted to take her off the
That's the
ketamine
point.
and put her on an antipsychotic.
Point for Anderson. Point for Anderson. There's a point. How long did it take him to get there?
Is that
It
right?
was as a PRN as needed to help transition her off of the infusions.
All right. And your belief about the weaning of the ketamine was you thought, I don't know if it's just you, but you thought that ketamine had physical withdrawal symptoms. Is that right?
When you review ketamine, it's uncertain, but we do know that it does have psychological withdrawal. And so patients who are abruptly taken off of ketamine, who have been exposed to it over time, can have a psychological withdrawal, like other psychedelic medications.
Psychedelic medications, right? Okay, so now, during this time, in reviewing your records, I don't see a single note, and correct me if I'm wrong, there is not a single note about any physiological signs of withdrawal by Maya Kowalski. True?
Point number 2. There you go. There's a lot of time that's passed, guys. The clock is running real quick. That clock is moving faster than you think. The lead up to the question is taking too long. It's taking too long. The lead up to the question. Come on. You got to get there, Mr. Anderson. You got to get there.
True?
Again, usually you do not see physiological withdrawal with ketamine, and she was still on the infusions, and so usually you will see withdrawal once you have removed the medications from the patient.
Mm-hmm. Well, she was eventually removed, right?
She was off of the ketamine on Wednesday, which was my last day taking care of her.
Do you know how many times she had been on and off ketamine in the preceding year?
I know that she was receiving ketamine infusions on a regular basis, yes.
And did you go back before testifying here and review any of the records going back the past year?
Not in regards to how often she was getting ketamine, but I knew that she was getting it on a regular basis.
Was it true that they had been seeking, the Kowalskis had been seeking advice and treatment from Johns Hopkins going back to even before the July 4th onset of the CRPS?
I know from reviewing the medical records that are in our electronic medical record that she had been seen at our hospital. Yes.
And through that period of time, after Dr. Kirkpatrick's diagnosis in September of 2015, Johns Hopkins records uniformly stated CRPS as a primary diagnosis. Sure. Up until this point, anyway. True?
What's the legal basis of the objection foundation? Overruled.
Can you repeat the question, please?
Sure. After Dr. Kirkpatrick first identified this as CRPS, September 23rd of 2016, in every visit after that, up to this point, Johns Hopkins physicians had identified this CRPS as the primary diagnosis for Maya Kowalski. True?
The mother provided that as a diagnosis, and so when we take a history, we ask families about their past medical history. And
you're dodging. Anderson, you got her. You got her. What are you going to do with it? What are you going to do? She's dodging. Hammer in. Interrupt the answer.
When a family member tells you that their child has something, we believe them. We don't on every diagnosis go back and re-diagnose it.
Well,
There's a trust within a relationship that you develop with a family and a physician.
I thought my question was simply that, was that the primary diagnosis over that period of time? Is that
It was one
true
of
or
her- It was
false?
one of her diagnoses.
Well, if the jury were to look at these records, would they not find out that CRPS was the number one diagnosis by each and every doctor over that period of time?
There you go.
I don't know how everybody writes their list of diagnoses.
And so you went back through the records. So certainly you must have seen that she'd been to Dr. Kirkpatrick. And then Dr. Wassenauer was her treating, ongoing, I guess you all call it, attending pediatrician,
It's a primary care provider.
primary care provider. And then she'd been to Dr. Hannah.
Mhm.
Right? Or what in-depth conversations did you have with any of them about the need for the ketamine to treat CRPS?
I did not have any conversations with them.
I'd like to talk for a moment about intrathecal pump. By the way, is that FDA approved, intrathecal pump?
I'm not sure.
Okay. And isn't it true that Maya Kowalski learned about intrathecal pumps in a CRPS chat room as a possible alternative? Didn't she tell you that?
I don't believe she told me that.
Did she tell you that she was looking for ways to reduce the amount of medications in Maya?
She did not say that specifically.
Isn't it true that an intrathecal pump, one of the main advantages of it is that it reduces the amount of medication in the child's system?
It can.
Well, isn't it just the idea here, putting a tiny amount into the spinal cord as opposed to having it run through the whole body?
Took him 20 minutes to get here. $20. This is the good part.
Again, I'm not an expert in intrathecal pain pumps. I'm not a chronic pain chronic pain physician. I'm a critical care physician. But the hope is that it would provide better control of the pain at lower doses. Correct.
And you've had parents with children in extreme pain ask you about that previously.
G'day, Matt.
No,
But you weren't a pain management specialist,
no,
right?
I'm a critical care physician.
And so I want to talk for a moment about Nemours, if we could. Did you ever get a chance to look at the form that the Kowalskis were asked to sign in order to transfer Maya to Nemours?
No.
Is it true that Maya Kowalski wanted an inpatient CRPS program?
I was just told that she was interested in the Moors. The difference between inpatient and outpatient, I don't know the specifics of what she was.
It turns out that Nemours, after you talked to him, you found out that Nemours did not have an inpatient CRPS program. It was outpatient, true?
Correct.
But they did have an inpatient pediatric psychiatric program, didn't they?
I do not know.
Good point.
Do you know whether the codes on the release authorization the Kowalskis were asked to sign were coded for psychiatric problems such as Munchausen by proxy?
No, I don't know.
If they had signed on to that.
He continues. We have to get to the rest of it. So I'm going to go to the jury questions. We are going to the jury questions. The jury questions as at 1:54:36. Let me get to that point. 1:54. We'll go about there. And then, you know what? You know what we're going to do? You know what we're going to do? This is what we're going to do.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
The jury.
All right, jury.
Bring the jury.
Jury's out of our presence. Dr. Smith, if I can have you wait outside as we go over these questions outside your presence.
Oh, recovery act. Is this the part? No, it's the afternoon session where they do it, right?
Okay, Dr. Michelle Smith is outside of our presence. The first question, at the time you saw Maya, you just testified there, quote, red flag, end quote, did, quote, you, end quote, call the child abuse hotline to report your, quote, red flags, end quote, or did the hospital just reach out to Sally Smith off the record first to come in and give guidance on the case first as an expert? Here's the page.
Objection everywhere. That's a fishing expedition by the jury. That's a fishing expedition by the jury.
Howard, can you speak up more?
I'm sorry.
I don't have my headphones on.
Oh, okay. Jeffrey Jack, that's got more landlines than normal beaches.
As much as
It's
I like
got
counsel, I-
Hunter, Judge, I object. That's got more landmines than Normandy beaches. And he's right. That is a fishing expedition, argumentative, leading outside the scope. Every objection. Oh, man. Oh, my God. Oh, it's got more landmines than Normandy beaches. Wow.
read that question.
Court sustains the objection. We will not answer that question. Read page number 2. As the treating physician in the PICU, what diagnosis were you treating Maya for? We have seen her admitting and discharge diagnosis on her discharge paperwork as conversion or factitious disorder, or question mark. Can you tell us what your diagnosis was as the treating physician? If you meet as a team to hear about the weekend to take over, would the physician you are taking over for tell you they considered leaving AMA?
Isn't it great, Kristen? The jury swoop.
I can't object. I think those are fair questions.
Okay, court will ask them. Read page number 3. When signing discharge papers, does that admit the patient to agreeing with the diagnosis, or does it only acknowledge receiving the discharge information? Next question. Do the same answers apply with transfer orders?
Legal conclusion. It calls for legal conclusion. Why are they debating it? It's a legal. No, don't let the jury answer that question. Don't let them ask that. Calls for legal conclusion.
I just need whether someone's objecting or not. To the first one? And your position, I guess I agree with both of them. Do you object or not object?
Oh, come on. Anderson, you know better. Come on. It calls for legal conclusion. Don't fight it. I know you want the answer, but no.
Number 4. How much IV hydration was Maya receiving at the time in the PICU? Was she taking any oral intake? When Maya stopped ketamine in your hospital, did Maya show any withdrawal symptoms in your hospital? I'm sorry? Okay, read page number 5. Dr. Smith, you referred to ketamine as being like a psychotropic medication. This, to my knowledge and remembrance of testimony heard in these proceedings, is the first time the words ketamine and psychotropic drug have been used in the same sentence. Is ketamine in a medical prescription description listed as a psychotropic drug, or is ketamine listed as a drug and only the or possible temporary side effects could be brain fog or hallucinations?
Medical prescription description. She said psychic. I think she never said
Yeah. We don't want the juries to be in the camera.
All right, jury enters.
I'll object to number 1, but not 2.
Overruled. I'll ask it. Okay. Anything else, or can we bring in the jury?
Jury.
Okay, please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And while you were on break, did anyone approach you about this case? Did anyone review any media accounts of this case while on break? And members of the jury, I reviewed the questions outside the presence of Dr. Michelle Smith with the attorneys. I'm going to be able to ask some, but not all of them. Dr. Smith, as the treating physician in the PICU, what diagnosis were you treating Maya for?
So we were treating her for an acute pain exacerbation, and we, at that point in time, had the CRPS diagnosis, but this was an acute pain exacerbation that we were treating and managing with the pain team. We also were evaluating her for the abdominal pain that she came in, and so the GI service was also evaluating her at the same time.
We have seen her, meaning Maya Kowalski's admitting and discharge diagnosis on her discharge paperwork as conversion or factitious disorder. Can you tell us what your diagnosis was as the treating physician?
I took care of Maya for the 3 days, and that was my only time with her. And at that point in time, we were treating her for an acute pain exacerbation and abdominal pain with the diagnosis of CRPS.
Next question. If you meet as a team to hear about the weekend to take over care, would the physician you are taking over for tell you that they, meaning the Kowalskis, are considering leaving AMA?
Yes, that would have been discussed with me during any handoff.
Next question. How much IV hydration was Maya receiving at the time in the PICU?
The exact amount I'm not certain, but what we would normally do is put them on normal maintenance fluids. That would be the requirement for a person who's not eating or drinking anything at that time.
Was Maya taking any oral intake in the PICU?
I think she was drinking a little bit and not eating much solids.
When Maya stopped ketamine in your hospital, did Maya show any withdrawal symptoms in your hospital?
We discontinued the ketamine on Wednesday, and that was my last day taking care of her. So I would have only been involved with her for several hours while she was off the ketamine.
Next question.
Great.
You referred to ketamine as being like a
Great
psychotropic medication. This, to my knowledge and remembrance of testimony heard in these proceedings, is the first time the word ketamine and psychotropic drug have been used in the same sentence. Is ketamine in a medical diagnosis description listed as a psychotropic drug, or is ketamine listed as a drug, and only the or possible temporary side effects could be brain fog or hallucinations?
Good God, is this jury listening? My word, is this jury listening to everything? They are listening, even if they might have a position or a thought, even if they might be pro plaintiff right now, they are listening to every single word. These are great questions.
Ketamine is a dissociative agent, and so that is what we typically talk about it as a dissociative agent, and it's used for anesthesia. When I use it, it's used for sedation. I'm not sure if that exactly addressed that question.
I'm sure if there's further follow-ups, they will ask.
Please.
Defense, do you have any further follow-up?
Just a couple, Your Honor, I think. First of all, to be clear, Dr. Smith.
I don't have time. I need to get the fireworks. I need to get to the actual part of everything that we went through today. So I have to get to Dr. Teppa Sanchez. I have to, because I am not going to, because there's almost no questions of her anyways. Here we go. Dr. Teppa Sanchez.
Good morning.
Good morning.
Could you tell us
Pause for swoop. Pause for swoop. New swoop. Okay. Now, Teppa Sanchez.
name, please, ma'am?
Beatriz Teppa Sanchez.
Okay. Dr. Teppa Sanchez, where are you from?
I'm from Venezuela.
What is your job today?
I'm a critical care physician at All Children's.
And how long have you been at All Children's Hospital?
Probably close to 8 years. I started in 2016.
Would you tell the jury how you received, where you received your education and training?
Sure. I went to medical school in Venezuela. And then right after medical school, I did all my requirements, testing and everything to be able to come to the United States to do my residency. So I got married, left the country because of the situation of Venezuela, and came to Texas where I did my pediatric residency at the School Children's Hospital. That was for 3 years. And then I was accepted at Emory University in Atlanta for my critical care fellowship. After that, I was able to find my dream job. Also, my husband's a physician, so that's at St. Petersburg, All Children's, and that was my first job as an attending.
Okay. And you've been, you said, with All Children since 2016?
16, yes.
Okay. And are you board certified?
Yes, I am.
Would you tell the jury what you're board certified in?
I am board certified in pediatrics and also in pediatric critical care medicine.
I keep trying to remember to ask this question. I haven't done it, so I'm going to ask you. What does board certification mean? What do you have to do to be board certified?
So basically, you have to study a lot and present the exam. So the boards, the pediatric, American Academy of Pediatrics, have boards for general pediatricians. And then they also have boards, the American Board of Pediatrics also has boards, which is just a big test that goes, it's like 4 hours or sometimes even more, through all the general requirements that a person that is trained on that profession should be able to, pass those testings.
Okay. And you've maintained your board certifications?
Yeah, and it also includes not just the test for that. You have to do maintenance of certification. So basically, throughout those years, you have to accumulate points with going to conferences, taking extra trainings, like 2 or 3 days seminars and things like that. And each of those have specific points. So you have to reach a certain amount of points to be board certified.
Now, have you brought your notes from your care of Maya Kowalski with you today?
Yes, I have them in front of me.
I need to know that so I know what you got.
I have my HMP, which is my history and physical, on the day of admission on the 7th. I have my progress note from the 8th and my progress note from the 9th.
Okay. So let's start by you're telling the jury, if you would, when it was that you were involved with Maya Kowalski's care.
So my involvement with her care was basically on the day of admission to the ICU. That is on the 7th, that during the afternoon. So I understand she came to the ER first and was there for several hours as, the evaluations were being done. But then she actually arrived to our ICU that afternoon. I believe it was somewhere probably around 4 p.m. or so. It's kind of my recollection, but I'm not 100% sure.
Okay. And did you just happen to be the pediatric ICU intensivist on duty that day?
Yeah, there's usually 2 of us during the day and 1 at night. So during the day, the call about presenting the patient was given to Dr. Farhan Malik because he was the admitting doctor that was taking care of all those admissions that were coming. And then he would be the person that would assign either to his team or to my team, and based on number of patients and acuity. And at that moment, it came to my team.
And have you ever met or heard of the Kowalskis before?
No.
Have you ever had any contact with them?
No.
And just for purposes.
Forewarning, I was expecting this witness to be all of the fireworks. Dr. Teppa Sanchez. So the corporate defendant has the opportunity to designate a corporate individual to sit on behalf of the corporation in the courtroom for most days, a doctor who's attending. Dr. Teppa Sanchez has been there for the majority of the time. She has been in the courtroom for a lot of these witnesses because she is the body of the corporation for a lot of this testimony. So I'm sitting here going, this person, not to mention, she does have a very spicy personality. That's not a discredit. I was raised by a Latin woman. I know the fire. I know that ambition. This woman learned medicine in a different language and does it in a different language. Holy crap. Amazing. I really expected the direct to be a lot longer. I expected this witness to be the one that the defense thought was going to crack the case for them, like to break the case open. I was waiting for the defense to just use Dr. Teppa Sanchez to start throwing the shade. But they didn't. Like they did a little bit. But not a lot. I was waiting. I thought she was going to get aggressive in testimony, and she said the things that I thought were there. She said the curse words. She accused Maya of cursing, calling her an effing bitch or whatever it was. But wasn't like what I thought it was going to be.
Usually I end at 5 p.m. is when we do our sign out for the night team. So if you can say she got to our unit about 3 or 4 p.m. So it's towards the end of my shift. My shift consisted of coordinating, getting as much information as we could, coordinating and making sure that the right people were involved in her care, and creating a plan for specifically the most immediate plan, which would be that evening and night, to get her stable during that time.
And when you say you developed a plan, who did you develop it with?
The pain team, which was Dr. Jenny Dolan, and the ICU team. I believe Dr. Dolan spoke with other members of the pain team during that time as well.
And what was the plan?
So the plan was to stabilize Maya and make sure that she wasn't at the level of suffering that we were seeing, and included the medications that I just stated, which are the infusions of ketamine and Precedex, propofol during that first night for a specific amount of time. I believe we said 4 to 6 hours. And then if there's still significant concerns of her abdomen, at some point getting the CT scan.
Okay. During all this discussion with the mother and review of what had gone on, did you receive any information regarding what ketamine or what other drugs the patient had been taking?
Yes, the mom informed me of the medications that she was taking outpatient.
Chad is thinking that I'm being too nice. I'm not. She's their trained witness. She's their trained witness. They have her designated there because she is their trained witness. They thought the plaintiffs were going to go hard at her. So they had her in court to watch the whole time. They thought the plaintiffs were going to attack her ruthlessly. That's why they had her in court. I would have done the same thing. If I had a chance to put the witness that I relied on the most in court to watch how my opposing counsel cross-examined everybody else, I would have done it. Be like, because there's one thing for me prepping them, and there's another thing for them to see it happen. This witness was expecting to be ruthlessly crossed. She was prepped out the wazoo down to the clothes that she's wearing. This was the defense putting on a witness that they wanted to see the plaintiff try to skewer.
Not all of them, there's like vitamins and things like that, but mostly the ketamine treatments that she was receiving. She did mention that she was a patient of Dr. Kirkpatrick and Dr. Hannah, and that she would go regularly to get, depending on where her, exacerbation of her pain was, to get these infusions of high doses. She told me all the doses of the ketamine to kind of, in her, kind of explanation was to try to break that pain. She also mentioned that she had been to Mexico for I believe was a week, where they did an infusion of high-dose ketamine, and that she was intubated during the time. And that at this, on our admission, she was asking me.
This is a whole lot of details. A whole lot of details without a question pending. So many details without a question pending, with specific dates, times, durations, etc. This is a lot. This is a lot of detail. Oh no, we're not skipping this witness.
Start those medications, the ketamine at those doses, and that I needed to intubate her. That we had to intubate her and do the whole, kind of a week or whatever, how many days it would require, because that's the only thing that would take her pain away.
During all this exchange, were you given any indication of what the diagnosis of this patient had been at Lurie Children's Hospital?
No, she did mention that she went to Lurie's at some point within the last year to Chicago for a second opinion. And I believe it's in my HMP as I try to summarize everything. But that she went there, she didn't really.
The hospital is so pissed right now. They're so mad. This is staged. Look, every witness is staged to some extent. Every bit of testimony is staged to some extent. This is staged. It's in my notes as I try to document everything. So of course these notes are accurate. This is theater. Remember, this is theater. The courtroom is theater. There are dress rehearsals and practice beforehand. The courtroom is theater. Everything. It's theater. Both cases, both sides, plaintiffs and defense. It's theater.
Tell me what the diagnosis was.
And with respect to Tampa General Hospital, were you told of her being evaluated there, or what the diagnosis may have been?
She also said that she went to Tampa General. I don't believe she told me in details. I don't recall that, and it's not in my records.
What were you told regarding what the patient's diagnosis was?
She said that her diagnosis was CRPS, but that it was all in her entire body. Manifestations were in her entire body. And then she also said that she had a history of asthma, for what she went into all the details of prior asthma or coughing visits to the ER, to the pulmonologist, which I then went to the records to, because some of them were in our institution.
Were there, now this was in addition to the abdominal pain?
In addition, yes, sorry.
And did you arrive at any let me back up, Matt, just ask this way. Who was it that was undertaking to manage the patient's pain medications?
During our admission or before? During our admission?
At this point in time.
It was, I seek guidance from the pain team, and they would tell me the plan with the medications. And then my job is making sure like the rest of her organs and everything else is stable. So I would look at their plan from the pain standpoint and just make sure that I was monitoring the right things for the medications that were being utilized.
Did you call for any other consultations besides just the pain team?
That first day?
Yes, ma'am.
Consultations, I don't believe. Oh yes, we did. I talked to mom about, she expressed a lot of level of stress, and as part of my basic knowledge of chronic pain, we always know that there's a psychological stress that probably needs support with counseling, and so I did offer and told her that we were going to consult our psychiatrist.
Okay. And what was there? Were there other consultations ordered as well?
Not that day we did not communicate to the family of any other consultations.
And was the psychiatric consultation conducted?
Conducted, no.
Why?
The mom didn't feel like she needed that.
Okay, so when
I believe actually the psychiatrist came. Sorry to interrupt.
Okay.
But the mom didn't want it.
Okay. So what was the diagnosis upon admission to the PICU as far as you were concerned?
Yes. Let me just refer to my notes for a second. So in the ICU, we have chronic diagnosis and acute diagnosis. The chronic is pretty much relating to the history. So it's complex regional pain syndrome, and the second one is mild persistent asthma. But our acute diagnosis at the time were acute generalized pain exacerbation and abdominal pain. And there was a notation of constipation seen in the X.
Okay, this isn't the fun part. We're going to fast forward a little bit. 3:04:10. Let's go here. We'll start here. We're going to go real time. Courtroom mic is muted. Here we go.
No questions.
Members of the jury, if any of you have.
Uh-huh. Uh-huh. I just about lost it. I just about lost it. You know what? Kiyomi? Where is this? Cute reaction though. Agree. Cute reaction though. Yeah. We're gonna rewind a little bit. Let's go to the sidebar. So we have them approaching sidebar. Let's get the question, sidebar, argument. Look, they're arguing over a question because surprise, court arguing questions.
And so when I went into, she had mentioned that she was doing like IV fluid infusions at home, that she would do them herself, and also IVIG. And so when I went into a lot of
39.
Okay, fast forwarding.
Thank you. Did you continue to see
communicate with mom over the phone?
Okay. And what, if anything, about the treatment plan changed on Saturday and Sunday?
Not much, to be honest. During the night, we did the propofol only the first night. So the only thing, we continued the ketamine infusion. It had gone up on the dose a little bit by that Saturday, from 3 milligrams per kilo to 5. It's my understanding after reviewing my records. We did not do any more propofol during the nights. And I believe that Saturday night she got the CT scan, which we didn't have the results yet by the time I was there during the morning on Sunday.
So by Sunday, was there a plan made to wean Maya off these medications?
So there was starting the discussions that on Monday we would start the wean process, I believe.
During that weekend, were the pain team continued to see Maya?
The pain team continued to see Maya, yes.
And did they continue to monitor her pain medications and her pain level?
Yes.
did it appear to you over that weekend that you were able to make Maya comfortable?
Yes, she was not anywhere near the state that she had been on that Friday when she came to us. And then I believe on my note from the Sunday, the 9th, after a sit down with dad and then mom was on the phone, dad did express that she was at a better state that Sunday and at a better control of her pain.
Okay.
And I documented that on my notes from Sunday.
Okay. On Sunday, did it come to your attention that the family wanted to transfer Maya?
No. Up to the time I was in the unit, they did not tell me. Oh, transfer, yes. Sorry.
Okay.
Yes, several times.
And did they indicate to you they were in agreement?
Yeah.
After October 9th, did you have any further contact with the Kowalski family?
No.
Were you ever involved in Maya's care after that date?
No.
Thank you.
Long pause. Long pause. Quiet. What are we doing, Mr. Anderson? Mr. Anderson, are we going to cross? Mr. Anderson, what are we going to do? Watch. Watch. Watch carefully.
No questions.
Members of the jury, do any of you have?
That little eyebrow raise might have been a premature expression of excitement. She raised the eyebrow to the jury. Karen G, thank you. Tell Yadira, I remember, and her chancla, that she did a great job. Latina fan here. Yes, Yadira, my niñera, who raised me from Panama. I have two moms. I have mom A, mom 1. They don't come in chronological or any alphabetical order. They are mom A and mom 1. I have Mama Morton and Yadira. They both raised me, and my dad, Bruce, who passed a few years back. Yeah, so Yadira raised me with her chancleta was what I was learned to fear, as if it was the holy arm of God coming to strike you down, because that's what a chancleta does. That was a distraction because, Esme, do you think not doing cross was a strategy? Hell yes. Did it take me a long time to get to that understanding? Oh, yeah. Not doing cross was a remarkable strategy. This witness was so well prepared and scripted and brought on at a time when the jury has already shown skepticism that I think Anderson was. This is a risky wager. This was a risky move. Mr. Anderson, you are a gambler, sir, because I don't know that I would have had the stones to pull this. No questions. No questions. Teppa Sanchez was like, what? Little do we know that we get to do one of our favorite things, which is to...
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
God, Emily, thank you for letting me use that clip. Thank you. Thank you for letting me use that clip. Bring the jury and the questions from the jury.
Right.
Oh, and say her name and she shall appear. Did you hear me calling your hair out? I think that's what you did. Do you want to hear it one more time? Tremendously bold move, but they know the jury and no questions dismisses the testimony entirely. Yeah, and the jury's like, give me all the questions. So, shall we one more time?
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
Oh God, it makes me laugh so much. I love it.
Do not discuss this case amongst yourselves. Do not do the investigation. Receive no information. All right.
Sanchez,
You can step outside as well.
All right, the sidebar we hear. Spinning wheel, stop.
Flurry of confusion.
Oh, yeah, hang on. This is a good one. Hang on. I gotta rewind. No, Emily, you distracted me. Emily, you distracted me. Oh, ADHD in the chat.
Mode or the mood.
Thank you, Emily, for chiming in. I know you got
Did
laundry.
Maya spend in the ER before being transferred to the PICU unit? 2, when Maya was transferred to the PICU unit, was the mode or the mood of Maya and parents a more even / calm level, or was there still a flurry of confusion?
Matt. Better than Beetlejuice. Say her name once. Emily, that's great.
Yeah.
My partner says we agree.
That sounds like I think that's what, 2 agreements today? 3?
2 agreements. We have 2 or 3
Not
today.
have The introduction. Okay, red number 3. Did you discuss with Dr. Michelle Smith that the family wanted to leave AMA? Why was the family not able to leave AMA? Isn't it protocol to chart in your charting the end of your chart being discussed with family or parents?
No objection.
Red number 4. If someone tells you they want to go to quote heaven, end quote, or quote die, end quote, did you report that to anyone to see if she needed to be placed on a psych hold if she is threatening that she wants to die? Could you have not called the police or security if you had concerns she was going to harm herself? That's red number 4.
Okay.
Red number 5. Did the ER doctor, Bahar-Posey doctor, mention to you or the admitting doctor her concerns of possible child abuse that she testified about in her testimony? Do you have that documented of the back and forth of the ketamine dosages of compromising the 1 milligram per kilogram to the 3 milligram kilogram? Will the jury?
The jury is cross-examining the witnesses. The jury is cross-examining the witnesses. Lord have mercy, the jury is an attorney. The jury is cross-examining the witnesses. Do you have documentation to support your contention? Are you telling this jury?
Jury get to see that.
Okay. The first question is dangerous. Invites a Japanese response. I think, yeah, we're gonna have to object on number 1, 2.
Emily, there's a reason I asked you for that for the bumper, because this jury has the bring the jury mood. I need you to record a snippet that says, bring this jury. Because the judge calls him this jury.
Do we have immunity for this call, Your Honor? Because if we do, I think it obviates the question. If we don't have immunity for this call, it might be something.
Well, the first question is the statement by the ER doc to the PICU.
Great comment.
And so it's just a question of knowledge.
Look at me. I am the attorney now.
I don't think we're gonna get in trouble. I don't want to be held to that. I think I was too nice.
Yeah, you know, my problem.
Is this something that I could preface it with a yes or no answer? Did the ER doctor?
Yeah, I guess you can say that.
And otherwise, we're okay.
I guess so.
Red number 6, on October 8th, why did you call Dr. Sally Smith as a consultant and not call the child abuse hotline? Did you not feel you had enough evidence for child abuse? Correct me if I am not correct. You could have just made a call to the child abuse hotline and not call Sally Smith to get started with CPI.
Oh my God. Argumentative, outside the scope. This question, to quote Attorney Hunter from earlier, who said a phrase that I think I'm going to steal for every trial I have from now on. That question has more landmines than a beach at Normandy.
Yikes.
Yikes.
We don't know
He
if
says
the
yikes.
There was a previous call screen on October 7th. So again, it's a dangerous question.
She needed a call with the major.
Oh, okay. Well, invite
Oh, this is a funny moment for trial. We're going to real time. Here you go.
irrespective of what the outcome was.
She doesn't know.
Yeah.
She'll say she doesn't know.
Okay, so she doesn't know what the status was. I think it's dangerous.
I think Danger Will Robinson is in order here. Not that we're lost in space, but there's a brand new episode about 5 years ago on
I
Netflix.
just told you about that. The robot.
Yeah. What do you watch on Netflix?
Take care of Maya.
Actually, I watched.
Attorney Whitney with the mic drop. I'll replay it for the chat. And he knows it too. He knows it. This was, it wasn't the Danger Will Robinson. It was the other part. No spinny wheel. I need you to comply. You will behave.
There's a brand new episode about 5 years ago on
I
Netflix.
just told you about that. The robot.
Yeah. What do you watch on Netflix?
Take care of Maya.
Actually, I watched. Dark Sky.
No, it's the robot. It's the international sign for flailing.
So I hear there's an objection to this this set of questions. Is that correct?
Okay. Yes, there's an objection, Judge. Everyone pointed it out. It is a full of landmines, more than there are at the beach in Normandy. What do you watch on Netflix? Take Care of Maya. Oh, baby. It was Whitney who said it. It was Whitney. And then he turned around because he didn't want to face the judge. Oh my God. That would have been also like, I would have ranked that second best. That's so funny. At least he didn't say Netflix. No Netflix, just chill.
Yes, Your Honor.
Okay, I'm sustained. Okay, so we'll not,
All right, let's get the witness back on the stand. Rebring
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
Okay, welcome everyone. Please be seated. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? And while you were away, you watched all sorts of media accounts about this case. Isn't that correct? And did you talk, or did anyone approach you about this case? Okay. And just to let you know, as you saw Dr. Teppa Sanchez walking in, I went over these questions outside of her presence with the lawyers. We're going to be able to ask most, but not all of them, but most of the questions we can. Dr. Teppa Sanchez, in your
Side note, the jury actually asked him the question before, whether the witness was in there when the question was being asked. So he has to clarify. He is now bringing the witness back in after the jury is seated. So the jury is now informed that the witness was excluded while the questions were being gone over. This is so epic that the jury, during the next witness, hands their questions up and grabs their bags before the judge dismisses them, knowing the procedure. This jury shall from henceforth be known as this jury. I need to make something that says that. This jury is this jury.
Your testimony, you mentioned, quote, die, end quote, and quote, go to heaven, end quote. May you please clarify who made these statements?
The mother.
Were these statements said within the same interview or over different meetings / conversations?
That was on the first day, on the 7th, when I sat down with her on the couch to get all the history and just kind of try to bond with her.
Are these observations clearly recorded in the Johns Hopkins All Children's Hospital medical records?
I'm going to quote my note and read. Mother states that she is extremely tired and is very stressed, and at times feels like she wants to die, unquote. She also expressed.
That was trained AF. Are you kidding me? Objectionable, but
Expressed that when Maya is in so much pain, she has also expressed she wants to go to heaven, unquote.
The next question, are the records that would document these statements entered into evidence? The answer to that is yes. Remember, the next question, you testified you communicated with Dr. Sally Smith. What date and time?
I communicated with Dr. Sally Smith on the Saturday, I believe was the 8th. And that was, I don't recall exactly the time, but it was probably after my morning rounds after seeing all the patients.
What documentation of this contact? Was it in an email or medical notation in the paper file or verbal with a written follow-up?
It was a phone communication.
The next question. How long did Maya spend in the emergency room before being transferred to the PICU?
I honestly don't know.
When Maya was transferred to the PICU, was the mood of Maya and her parents on a more even / calmer level, or was there still a flurry of confusion?
It was, the mood in the room was very chaotic in the PICU. There was a lot of screaming and words that I won't say here, but just very kind of aggressive at some point.
I want you guys to take a mental snapshot right now. Take a mental snapshot right now. Just imagine right now. I'm sorry, Miss Teppa Sanchez. I didn't mean to. I did. There we go.
No.
There we go. I did you dirty with the pause game. I repaused. Take a mental snapshot right now of the confidence with which you hear the testimony. The confidence, the poise, the prompt answers. Take a mental pause. Anderson passed on a cross. Mr. Anderson, this was the riskiest move you have pulled thus far in this trial, and chef's kiss. My hat is off to you, sir, because the confidence that she has answering these questions makes what we're about to see that much more impactful.
This next question changes this, Dr. Smith. Did you discuss with Dr. Michelle Smith that the family wanted to leave against medical advice?
No, because up to the time I was there on that Sunday, that was never brought up. The transfer to Nemours was what we were focused on, but I was never told by the family that they wanted to leave the hospital. So I didn't communicate that to Dr. Smith. Michelle.
So the next question, if you know, why was the family not able to leave AMA?
I don't know because I wasn't there.
The next question, isn't it protocol to chart in your charting at the end of your charting discussions with family or parents?
Yes, usually if there's a sit down.
No, do not send the jury or judge gifts. No gifts, none. I forbid chat. Do not do that. Do not do that. That will get my ass in trouble.
We do a little bit more detailed charting, and it's on my note from the 9th, my progress note from the 9th. There is a summary of my discussion that we had. We call it family meetings, where we sat with Mr. Kowalski. Ms. Kowalski was in the meeting over the phone on a conference call type of thing. The pain team was there and all the ICU team, and it's recorded in my note.
If someone tells you they want to go to quote heaven, end quote, or quote die, end quote, did you report that to anyone to see if she needed to be placed on a psych hold if she is threatening that she wants to die?
So I definitely consulted the psychiatry that we have available at All Children's for Maya. And when I started going into with mom about, a little bit more questions of how she was, she said, right now I'm okay. I have my family. I'm okay. I don't have those thoughts right now. So I said, we have counseling. Please communicate to any of us if you're struggling. So I did. That's what I did.
Could you have not called the police or security?
Reclarifying, this has been the corporate designee in trial for 90% of the case. People were asking me questions earlier. Most witnesses are excluded. Here's the thing. The party is allowed to be present during all parts of the case. So the corporation is allowed to designate a representative who is entitled to be present during all witness testimony. J. Hatch has designated Dr. Teppa Sanchez to be present for like 90% of testimony. She has been listening to all witnesses. She is exempt from the rule against witnesses because she is a party. She is the representative of the hospital when she's sitting at counsel table. So she was prepped. She was prepped for this. She knew this. She was ready for this. And when Anderson passed on cross, the confidence level goes through the roof.
If you had a concern she was going to harm herself?
At that point, I would have probably contacted our social worker and kind of asked what the proceedings would be if we had significant concerns, a mom, if she needed to be Baker acted, which is what usually we would do. But she was not my patient. She was the mother of my patient. So, you know, my involvement on how to proceed with that, I would have to seek guidance.
Now, this next question, if you can answer with a yes or no answer.
Sure.
Did the emergency room doctor, Dr. Bahar-Posey, mention to you or the admitting doctor her concerns of possible child abuse that she testified about in her testimony?
No.
Next question. Do you have the document or that documented of the back and forth of the ketamine dosages of comprising the 1 milligram per kilogram to the 3 milligram per kilogram?
I'm going to check my records.
Good move.
From my HPI, I do say she states that at this point she's having a crisis and needs to be placed on an induced medical coma in order to break the pain. And then on my plan, I just state the final doses of what we had agreed on to actually give Maya.
And for the attorneys, these records are in evidence, right?
I'm sorry.
Yes,
Yeah. Okay. So there was a next question is, are the jury going to be able to see if yes, these are in evidence? Okay. Next question. Was Maya dehydrated prior to arrival?
By the time I saw her, she had already received some therapies in the ER. So I did not appreciate like severe dehydration.
Did you identify?
Mini rant about the word appreciate. Doctors, pick a different word, please. Pick a different word. I did not observe. I did not observe. I did not document. I did not see, hear, feel, sound. You use the word appreciate. I know the context that you're using it in, but us normal folk, I say this as a lawyer who uses Latin. Can you stop using the word appreciate all the time? Like, I appreciate you not using the word appreciate in the place of the word observed. I'd appreciate that. Thank you.
By Maya's nourishment level?
I did see kind of on my initial impression that she looked very thin. And, you know, we kind of follow the weight. I did consult, I believe, well, it's standard of care. All of our patients get a nutrition evaluation. I honestly don't recall if that was done that day or the next several days.
Please describe, quote, SCD, end quote, for preservation of blood clotting. Was this from Beata or without Beata's mentions?
Most of our patients that are a significant size can get this. They're like a pneumatics, almost like socks. They compress your legs to prevent blood clot. So almost all of our patients that are in the ICU, we discuss every day if they need any type of blood clot prevention. These are the least invasive. They're medications that you can get for preventing. So these are the least invasive that are most effective. And some patients actually like them because it's like a massage on their legs, especially for the patients that are immobile and things like high risk, like having a central line or a port would put you at a higher risk. So we have our quality list that we go through every patient when we do rounds in the morning, and we go through all of this list to make sure that we discuss this with every patient that we round. And then her, you would see that was initiated because she was at a higher risk.
Your administration of ketamine sounds incrementally moving slowly and methodically up. What is the reason of dosing of ketamine is done this way?
So initially, like I said, what I'm used to prescribing ketamine are lower doses. So we started at the 3 milligrams per kilo per hour. Overnight, the night team, because of whatever concerns and pain, they actually did go up to 5 milligrams per kilo per hour. So usually we go by how the patient's responding. As we had gone up, make sure the vital signs and everything, all the organs are stable. And I believe that was
So if you missed that, J Hatch does actually give ketamine. They do titrate with ketamine. They do start increasing the dosage of ketamine. They do start on ketamine with Maya, and they start increasing the dosage. So the jury is picking up on the titration that we heard from previous witnesses. So this is the titration part where you're getting up to a therapeutic level. Internet, I swear, if you don't start behaving, I'm going to go smack the router with a golf club. That won't help, but
It's
it
the highest
needs
dose
to.
we provided her, at least during the weekend.
That completes the jury's questions. Mr. Hunter.
Dr. Sanchez. Let's start with the last one. You
Let's
said
be
you-
honest. We don't want to hear Hunter right now. I don't.
Of course, words in my notes. I do think at some point, I don't.
Hang on. Might have already missed it.
A 10-year-old would drop an F-bomb and other things, right?
Okay, here we are. So Hunter asks like one question. And then Teppa Sanchez is like, but you didn't cross me earlier. So what are you going to say now?
Aggressive speech. What are you talking about?
It was Maya being 10. It just really stuck with me because she would first saying the F word and just kind of towards me or the nurses, screaming. At one point, she actually was spitting. So that was not something that we see in pediatrics.
Are we to believe that you, my dear, don't use the F word ever? The F word. Some might call it an F-bomb. I have F-bombs. I throw them around. This is an F-bomb. Welcome. That's an F-bomb. I have F-bombs. I throw them when I can't say them out loud. Just you can throw the F-bomb.
That's all I have. Thank you.
Any questions, Mr. Anderson?
That must have been pretty amazing to you that a 10-year-old would drop an F-bomb and other things, right?
I mean,
this is the time when you come in swinging. Now, nice timing, Anderson. Nice timing. Now you go for the
it
knockout.
was surprising, yes.
Okay. How come you didn't put down any of the specifics of that in any of your notes?
I don't tend to put
Boom.
course words in my notes. I do think at some point, I don't recall where. I mean, in my HMP, I did say that there was aggressive language.
Well, now you're saying that it involves a 10-year-old little girl talking about F-bombs and so forth. You didn't think that was significant enough to describe in your notes?
Can I have a moment to find it? Just
This is what I was talking about. When you come in swinging, land the punch. That's a landed punch. If you come in swinging to a witness on cross-examination, if you're not doing the subtle build-up to then deflate them later, if you're coming in hot, you better land that first punch. That's a landed punch. That's a landed punch. I repeat myself too often. Someone made a comment. I can't get over it. F-bomb. We're going to toss one just for this because this spinning wheel of death right now is getting. There's an F-bomb.
might be in my physical exam.
Good on you, Anderson. Wait.
Okay.
Good on you.
It's
Waiting.
after the abdomen on the physical exam. Very difficult to examine as patient refuses to be touched and mother does not want us to evaluate further unless she's placed on anesthesia medication. Then neurologic. She's very agitated. Eyes are open with intact extraocular movements. No focal weakness. The next period. Very aggressive with staff. Not able to evaluate deep reflexes. I think I just kind of summarized it. I'm very aggressive with staff just because I don't.
But you said nothing about what you testified here in front of this jury, did you?
I just said very aggressive to staff. And to summarize all that, I don't tend to put specific bad language on my notes. It's a document, so I don't.
That's like offensive to you.
It is offensive to me.
Can we? Yes, I'm sorry.
Did you finish your answer?
Finish your answer about it being offensive to you.
It is offensive to me.
Okay, can we bring up 2175-004?
Oh, God.
It's in evidence. It's an exchange of texts.
Oh, Hunter, you know it sucks.
Okay.
It's okay. It's coming in.
If we could, you had just found out in this, can you see it there in front of you?
Yes.
Okay. And you just found out that ketamine girl's mom committed suicide.
Anderson, if you planned this, you son of a bitch, if you planned this, really, really well played. The offensive language part.
Right.
Yeah, I believe that was a text that let me know about that
Right.
months later.
And then you say, I know we did the right thing, but this is really F, and then
Yes.
ellipsis, or star, whatever you call it, up. I feel bad.
Yes, I put the little starts, then I wouldn't really text that.
But isn't it true? That's right. You don't have any remorse for any of this.
Objection,
Yes.
That was objectionable as hell. That was objectionable as hell. That was argumentative. That was so outside the bounds. But here's the thing. Here's the thing. Let me tell you a little secret that you guys don't really need to know about lawyers. We take shots. We do. We take shots. That was a shot. That question did not need an answer. That was out of bounds. It was off the mark. It was inappropriate. But it was chess. Chess isn't supposed to be, I mean, it's not supposed to be kind and nice. I get, I'm gonna get a lot of hate for this comment, but you are a zealous advocate for your client. Here's the thing. If Mr. Anderson knew in a deposition or in a transcript, or he knew in prior conversations with Ms. Teppa Sanchez that she didn't have remorse, she didn't care. If he knew that, wouldn't you want him to say it? The question is objectionable as hell. The objection comes real fast. And the judge immediately calls a sidebar and says, Anderson, you get your shit in line and you don't say that crap in front of the jury ever again. That was a ballsy move. And that's like a once in a trial. You get that. You get that one time in a trial where you step that far out of line. And he had to do it here. That was risky. That was risky. Risky. But my God, man, it was risky, but it might have been effective. But the jury makes a comment about the giggle. They say in the future, make sure that the attorneys don't giggle. I might have to cover that tomorrow night because it's getting late. But we'll go beyond the sidebar to where we pick back up. The shaking of the head as in disgust. I get it, Ms. Teppa Sanchez. I get it. It was an unfair question. That's unfair.
I'm going to ask
With
the juries to disregard the question.
All right, but you seem to be okay with texting the F word.
To a
Is that
friend.
right?
To a friend. I even put the little stars because I don't like to.
Well, and you talked about venous thrombosis. That's a blood clot in the legs.
Yes, where they usually initiate in the legs. So that's why we target.
And these are like the silent killer that can, in children, break free and travel to the heart.
So actually in children, there's a lot of, kind of studies going on, but there is blood clots do originate in legs, adults or children. But we have had patients that they can break and go to the lungs. The lungs are like sponges, and a lot of the children actually tolerate that. But we still don't want that happening. We try to prevent them.
But they can, if they go to the wrong place, be fatal. Can they not?
They can.
So if Beata Kowalski was concerned about her daughter staying in a laying down, supine, I should call it laying down situation, and blood clots going to Maya's heart, that would be medical knowledge you would agree with.
Anybody, including us, would be concerned. Yes. And the protocol includes SEDs. We do physical therapy. Anything that encourages movement prevents.
And insofar as the amounts of ketamine involved, you have no particular expertise in ketamine, especially at that time, right?
I had expertise, but for different indications. We use it a lot.
How many years were you in practice as of this date, October of 2016?
For critical care. So pediatrics, by then I had probably been off residency for about 4 years.
Off
And
residency?
For pediatrics, yes. And then for critical care, that was a year. But I did 3 years of fellowship.
All right.
This is still too long. Anderson, still too long. Still too long. Still too long. Time, my friend. Time. Make your points. If you're shuffling papers, it's a sign you're not going to find the document before you have to ask a question. You don't have the benefit of the clock. You don't. I have the benefit of spinning wheels. Thank you, Laura Leanne, and thank you, Jem. I have to start pulling up some super chats that are not questions. Please keep an eye on the screen. I am sorry. I am sick. If you guys can still hear, I need meds so bad, and I need sleep. I have to start pulling up chats, and we're going to wrap after this witness, and I'll bring on the next one beginning tomorrow. I promise.
Nothing further this time.
Anything further, Mr. Hunter?
Very briefly. The text messages that counsel showed, were those from your private phone?
Yes.
As opposed to the medical record?
Yes.
Thank you.
Anything further, Mr. Anderson?
Judge,
You have another question? Okay.
for the reference to text messages we talked about, were those about 3 months after you last seen this patient?
Yes.
Thank you.
Your Honor. Any further jury questions?
There's more. But wait. But wait. But wait. There's more.
The court has said our favorite thing. Bring the jury. Bring the jury. Bring the jury.
I promise not to abuse this. I totally am not going to live up to that promise. Oh, lucky. I gotta wind stuff down because I'm struggling. So they go sidebar. While they're doing that, I'm gonna catch some questions. PD Warren, Rob is someone who listens while at work on third shifts. I appreciate and love your passion for this case, and I'm really happy you're here to help us walk through it. I'm glad to be here. This case means a lot, and I'm glad to be able to help people understand it because it's very complex, really complex, and I like breaking it down. And I take time doing it more than I should because I don't have a lot of like human time because, life, but I try my very best to break it down. Horse welfare. How can J Hatch simultaneously claim that Maya was faking her pain / Beata had MBP and defend administering a lot of medications? That was the point that was brought up on cross. Either J Hatch committed medical malpractice or the accusations were false. That point is being asked of the jury. That is one of their determinations to make. One with no name. Thank you for the generous super chat. Very kind of you. Welsh lady, I told you I started. I did not forget it. Hi, Rob. I have dystonia like Maya's. Please, can you explain that it is an involuntary neurological movement disorder and can change positions because it's not in Maya's control? Please. As they keep saying, it's inconsistent. Yes, this was something that is testified to by various doctors of moments when Maya appears to not be in pain versus when she appears to be in pain, or moments when the dystonia is present or not present. Imagine that your brain is in control of your muscles, but you are not in control of your brain. Okay. So your brain's in control of your muscles, but you're not in control of your brain. And the brain does that and says, feet, you're going to point in. Feet, you're not going to be able to function properly. Legs, you're not going to walk. Legs, no matter what you do to try and build strength in this muscle, you're not going to be able to do it because I'm not going to let you move it. That is what we're talking about.
Okay, Dr. Teppa Sanchez. Is it normal between coworkers at Johns Hopkins Ultra Children's Hospital to discuss patients as nicknames such as ketamine girl or other nicknames?
We
Oh. This jury has opinions. This jury has all of the opinions. Wow.
we don't, if we're doing it over our personal phones, if we have to, or we do, we don't like to put their names. It's an identifier. So we would maybe use a diagnosis or something that would make sure that the other person receiving the text could recall who the patient is without having to go into much detail.
Next question. Did you observe dystonia?
Did that answer make anyone feel more comfortable about that text? Because it was supposed to.
In Maya's feet?
To be honest with you, I don't recall seeing dystonia. There was a lot of movement of her legs, and maybe there was some inward deviation that I might have kind of described on the physical exam, but it was very hard to do a full physical detail exam. So I can't tell you with certainty if I recall exactly what I saw.
Did you apply SCD?
Yes, I ordered them, and the nurses is actually the ones that applied.
What date and time?
Let me recall. I'm sure you can go back and see at some point in the records what the orders were, but I believe it was on the 8th.
This sounds excruciating for CRPS. What was Maya's reaction?
I don't recall if they were actually placed, and I didn't recall having a discussion of how that she was feeling with them. It was ordered.
Next question. Did you document Beata's comments of death and going to heaven? Or sorry, you did document Beata's comments of death and going to heaven. Did you also point this out clearly to Dr. Sally Smith during your October 8th after your rounds phone call to Dr. Sally Smith?
I don't recall talking to Sally Smith about that a specific point.
Okay. Are you the one that said, quote, learned today, end quote? If not, do you know now who said it?
On the text messages, I'm assuming?
I believe that's what it's referring to, yes.
No, I didn't. I received that text.
You testified after Maya left your care about October 8th, you had no further contact, but it appears by private text messages you were, quote, keeping up, end quote, on patient Maya. Is that correct?
No, first of all, I took care of her until the
I don't need to give you the pro tip. When the jury is writing their effing questions with quote, end quote, when they are putting quotations in their questions to witnesses, that is an adverse position. That is cross-examination. They have done that with every defense witness. Every defense witness. Do you believe that, quote, end quote, they are cross-examining this witness? They are doing a better job than most attorneys that I see. Most attorneys doing cross will inaccurately recapture or quote or say back the testimony, or they'll try to like spin it. They actually pull a quote out from her prior testimony. You stated, quote, this. Do you mean that, quote, this is actually this? We know for a fact there's former law enforcement. It was actually asked in one of the questions. There's former law enforcement on the jury. We also know there's former medical personnel on the jury. Rather, on this jury. This jury is now a thing. This jury is now the thing.
The 9th, that's the Sunday. And I would have to see the messages because I never took care of her, and I don't think on the messages it says anything of that sort.
Would seeing the messages help?
Yes.
Okay, go ahead, put it up, please.
So I'm the one on blue if you guys are seeing that.
You mean the one that said it's really fucked up?
So I don't say anything there that I saw it again.
Thank you.
Text message after this?
Is this going to be more than like a minute?
1 minute. Okay. So I'm trying to find the text message. The entry learned today is not you, is that correct?
Learned it? No, that's not me.
That came to you.
That came to me.
Okay.
I am on duty.
Very good, thank you.
Teppa, did you say that doctors at Johns Hopkins are not allowed to use the patient's name outside to protect their identities?
We don't like to use our patients, like, at least me.
Well, I think you said.
I don't like to. I think, I'm trying to use my common practice and say, I can try to generalize, but I don't know what others do. I'm saying the reasons why.
We bring up 2116001.
Focus.
You know Dr. Dees?
I do not, Dr. Dees.
And she was
You're gonna have to check to him asking this witness about what other doctors are doing.
Sustained.
Come on, focus.
I'm not the judges just for the use of the name.
Well,
If Dr. Teppa Sanchez isn't a part of this text exchange, right?
Yeah,
No,
counsel's
it
not
was,
coming
for
yet.
external
so
doctors.
you lose.
Sustained. Anything further from the jury? Okay, seeing none, members of the jury, I hope you have a wonderful lunch. I'm going to ask that they be back at 1:30. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
And that began the famous 20-yard sprint out of this courtroom, away from the minds and thoughts and questions of the jury. Every witness has run the hell out of this courtroom. I think we need a reminder. This is a good one. Dr. Chopra, here we go.
Anything further from the plaintiffs?
No, Your You didn't see.
You don't understand. The jury actually gets asked questions too.
Are you serious? It's a nice day.
Plaintiffs, are there any follow-up questions?
Yes, Doctor, part of your review.
I'm only going to owe you $1.
Is there a
One question, $1.
is there a stop here? Do you have a button to push for stop?
I told you I'd pay you your $1. Yeah, it's going to be quick, I promise. Just to follow up on one of the jurors' excellent questions.
Those are the potential, yeah.
Okay, I owe you $3.
Oh, yeah, I know. And $4 there, $7 today. My day is done. He hates me.
Thank you for being here, and have a good afternoon.
Thank you very much.
Okay.
The 20-yard dash out of this courtroom. The 20-yard dash out of this courtroom after the jury gets a hold of the witnesses. This trial is going to be famous for that part. I mean, he hates me. He hates me. This jury is incredible. Whoever was in charge of voir dire was either a genius or an idiot. I don't know. Whoever was in charge of jury selection was either brilliant or really, really should be fired, because this jury has a lot of opinions. So many opinions. So we're going to catch up on super chats. I know there's a whole other witness. And here's the thing. I wanted to bring up a friend of mine with whom I have shared some time, and who a lot of you guys have actually come over from. And it's actually Recovery Addict, the channel Recovery Addict. And I wanted to do this because this case is remarkably sensitive in the subject matter being covered. And I have not brought on guests for this reason, because honestly, I trust my own words, and that's about it. And I weigh those words very carefully. when I talk about subject matter like this. But I will say there's been a lot of people asking for where can I watch this live? Well, here. The Recovery Addict has been, he's a YouTuber, and he's been live streaming it, and I have watched a few days of his coverage of this. And he has been remarkably respectful of all witnesses and all parties, and he has been he has a very well moderated chat, a safe chat. It actually, I was in there, I was hanging out for a little bit. It is amazing. So if you have interest in watching this live, if you do, I would very strongly advise that this is a proper and safe channel to do it. The Law and Crime chat is toxic AF. I mean, that chat is nasty. Recovery Addict has been doing a great job breaking it down, and he actually does, he saves questions for me. And I listen. I try to listen. And if he has questions, I want him to ask me. And you guys, I want you to ask me questions. If you see something on the channel when it's live, I mean, that's one of the big things. If you see something live where you have a question, I want you to remember it, because I can't watch all of it. But if you have a question, I want to answer those questions. I want to get to it. If you have a timestamp, that's even better, because then I can go to that specific moment. But that chat is great. That chat is a good dynamic where people can talk and converse, and he does a good job managing the chats. Please, guys, go show him some love, because he's put a ton of work in this. This is a lot of hours, man. And what you see behind the screen, like what you see over on this end, this is a snapshot that's like this big of how difficult it is to put this stuff together. And he does a great job at it. So please, if you want to live stream, I know that no other lawyers are doing it, and there's very good reasons too. I mean, this is a very complicated case. This isn't something you don't want to spitball on this. You don't want to shoot from the hip. The issues are too complex. That's why I do recaps. Well, that, and plus I have a full-time law job. But I try to be very careful in my remarks and analysis, and Recovery Addict is very careful in his interpretation of what you're seeing live. And he knows when to actually comment on legal stuff versus medical stuff versus things that are common knowledge. So I can't speak enough for how generous he has been to well, audiences and communities are a thing. The people that engage in this chat, the people that watch and follow this channel, they have done so with respect to this case because it's a safe place to talk about it. Because I'm not going out there shooting from the hip and giving crazy, well, not crazy, but I'm trying to be fair to both sides. I really, really am. I don't pretend to you guys that I don't have a bias or an outcome or a thought process. I try to be honest in what I tell you. He does the same thing. So please, if you want the coverage that's more watching full time in the full-time day, and I'm not covering it, please, I ask you and invite you to go do that. So up to you guys, but I did just want to throw that out there because he has been very generous. Because what he does at the end of his chat that I've noticed is he has every one of his live streams where he's been conducting court hearings, he has said that he wants them to go and watch the legal stuff, because he knows the scope that he's comfortable talking in, and he passes that off to me. And I feel honored that he does that. And everyone that he has sent this way has been remarkable participant in the chat, and I welcome them here. For those of you that are here, please consider subscribing, because honestly, I didn't know what I was doing when I started YouTube. I love being on YouTube. I like explaining the law because it's freaking complicated, and I wish more people took the time to break down both sides. So thank you guys for being here. I want to catch up on super chats real quick, and then I got to bounce because I need meds. I need meds and I need sleep. No, don't. No coughing. No coughing. Vez, I'll be on vacation in Mexico next week. I'll be on Replay Crew a lot. So here's my token of appreciation. Vez, you don't have to give it. I appreciate the hell out of you when you do. Thank you. Also, special hug to my favorite chat. Thank you, Vez. Nikki, thank you very much. If DCF questioned abuse, why wasn't Kyle removed? That's a question the jury's going to have to contemplate. Kat Yarb, are you feeling any better? No, no, I'm working on it. Alexis, I'm working on getting my CNA license right now. I have ADHD and I get myself through studying, knowing that when I'm done, I get to watch your coverage. Alexis, ADHD is a superpower if you use it right. I promise you, it is. Stina G, why is Catholicism bad, but Reiki is okay? That's a question that was asked by the plaintiffs in that deposition. Very curious. Delisandro, many consider Reiki. I'm going to say it wrong every time, as relying on otherworldly / witchery. It's not scientific, as she claims she is. Because she's perky doesn't mean she's a good witness. I thought she testified. I didn't find any issues with her candor. That's what I mean by that. There could be people on the jury that are offended by her. I'm just speaking for myself. Jenna Reagan, super unfortunate backlash from DA has caused those who need relief to be forced to live with pain as a result of suspicion. P.S. Thank you for everything, Rob. Thank you, Jenna. I try to inform. This is about information and putting it in your hands. Your hands. Get it out of my brain into your heads. Krista Love, it pains me to say the defense had a couple of good witnesses today. They did. The charge nurse after lunch really had me concerned. I haven't finished the day yet. I'm going to start the day tomorrow with that. I am. I'm behind. I got to move faster. I have to get the timestamps better. And with the judge increasing the days or the length of the days, I'm going to have to be more organized. So here's one thing. If you guys have timestamps or specific questions or times that you want me to focus on, that would be amazingly helpful for these recaps. That's the biggest struggle. Tomorrow, Recovery Addict. Recovery Addict has a link to the Zoom feed. One of the questions, one of the sessions where the jury goes and gets excluded from the courtroom, the one where they say, we'll grab our bags and see ourselves out. That is muted by Law and Crime and Court TV. So we don't get to hear from the live stream what's happening. But Recovery Addict, which is why he's a boss, what he does is he's sitting there listening in one ear and he's reporting exactly what he's hearing as if he's on. Ladies and gentlemen, the judge just was asked a question that says, were you in fact lying from the stand? Oh, that's objectionable in several aspects. Yes. Okay. We are not going to ask that question. Okay. Going on. But that's what he does for that particular segment. And I asked him, I said, can you help me out, brother, and send me that link? And he did. So I'll play that tomorrow. That's an additional shout out to him. Yeah. LK Ryden, she didn't sound combative. She sounds like a doctor. That's what they sound like when they get questioned. I didn't mind it. I really didn't mind it. I do mind the aftermath. I minded how the Hopkins handled a lot of the other stuff. Solo YOLO, what does Chapter 39 mean? Chapter 39 is the chapter in the Florida Code that grants immunity to investigations by the Department of Children and Families and those acting on their behalf. So Chapter 39 basically says this entity, Department of Children and Families, which is created by the legislature, that is empowered by the legislature, given that creative authority, and then implemented by the executive of the state of Florida. That body is immune, and therefore anything they task under that, anything they delegate under that is immune. That's Chapter 39. Lynn 2574, I'm embarrassed by how certain I was that I understood chronic pain until I started living with it. Thanks for taking this to heart and being open to learning. I am always open to learning. I am open to being wrong. I love being wrong because being wrong is an opportunity to learn something new. Every time. Casey Cat, as some here already know, and to explain how RSD works, I had a great day Tuesday. In the evening, in a snap of the fingers, I fought the urge to call 911. The pain was so bad. I was alone and scared. These doctors don't get it. This syndrome is unlike anything I've ever tried to describe to other people. And there is a very big stigmatism surrounding it where people don't believe it. I have a friend who suffers from this. And for a period of time, I was skeptical of the pain they were going through. And for that, I deeply apologize because I have learned so much in the time since then. I am sorry. This is a remarkable challenge to anyone that faces it. And for those of us that think we are tough, we are not. We do not face this. I'm speaking of myself. I do not face this chronic pain. I don't have to wake up every day and have to readjust my pain scale to a higher metric just to make it through the day. So my hat is off to everyone that is suffering through this. And I hope that we find appropriate treatments for this and that we actually respect the fact that there is such a thing as chronic pain and we need to give it appropriate care. I'm not talking opiates. I'm not talking drugging them to death. I'm talking appropriate care. Can we find a way to do that with empathy, please? Lindsay, did defense object when the time was requested? Oh, they did. Morgan, Rob, you ever felt like you're on the wrong side? All the time. All the time. I just said I love losing. I love being wrong. I love learning. Charlotte, I'm distressed by the lack of any voice here for CA or MBP victims. I'm not saying that at all. MBP and CRPS can coexist. After decades in pediatrics and K through 12 education, I've seen too many middle-class parents get away with it. Wait till the witness that we bring on first tomorrow, the afternoon witness, her direct testimony. Listen to that. There are concerns there. And I think when we get to the end of the defense's case, you're going to see more and more of that. This case still has a long way to go, and I'm trying to be respectful to both sides of the argument at every step of the way. Retired Nana, my daughter for years was told the pain was in her head. Then she was tested for Ehlers-Danlos, another misunderstood condition. She's more comfortable with ketamine. I know people like that as well. Thank you. Roro, question to be clear, when they argue exhibits every day, these are only the ones that the opposition object to, correct? Sorry, stupid question. Not a stupid question. That's a normal question. That's a very normal question. Yes. When they're arguing about it in the morning and afternoon, those are the ones that are not resolved by agreement. So there's an outstanding objection the judge has to resolve. That's why those are argued. Casey Cat, Rob, you pretend doctor's note also changes how every healthcare worker looks at that patient from the moment it's written, and thus we are here. Sorry. Casey Cat was talking to you about my pretend doctor's note, the one that I wrote on the little notepad. I think I deleted that. I did. I was going to pull it up. But yes, I wrote a little fake note on a notepad thing, and I basically said, here's hearsay within hearsay to try to explain it. This comment, your pretend doctor's note also changes how every healthcare worker looks at the patient from the moment it's written, and thus we are here. I don't disagree. I think there's a problem with that. Duncan, Idaho, does a defense attorney woman with short gray hair not seem belligerent with the judge to you? No, I don't think so. Saying judge with that tone of voice, I'm already biased, but it annoys me. No, I do that. And I know lawyers that do that too. I don't see a problem with it. That's just a courtroom comfort thing for me. That's what that is. The more comfortable you are with the judge, the more I will yell back at a judge, Judge, come on. It's a courtroom thing. Ali, maybe I missed it, but why does Dr. Teppa Sanchez get to sit with the defense for all of this? Corporate designee. I explained that a little bit earlier. Is she the point person for the defense today? Corporate designee? Yes, she is. Mary Montagnani, when this goes to jury, do you think they are going to go over all this? I personally don't. I think they're going to go over portions where they have questions. Bon, question, not a lawyer, so maybe a dumb question. No such thing. Why didn't this all come before the trial started? This case we are at docket number like 3,000 something. This case has been going on for years and heavily litigated. We have 52 orders for summary judgment, like an unknown number of motions and orders in limine. Navigating this is wild. Trial Watcher, thank you for the super sticker. Car ET, you have to put it in a primary diagnosis on every note, even progress notes. I know, I do them. You actively chose the diagnosis. Interesting. Thank you. Ergo Iron Fist, been in the hospital multiple times. Started at 8 years old. Doc bite, stents, quad bypass, stroke during recovery. My God. Stroke last month. I wanted to adopt every nurse that treated me. Yes, nurses and I don't like the remarks being made about the nurses. and about the physicians and about the people that are on the ground. Yes, there are bad actors out there, but by and large, 99.999% of these people are doing a job that is very thankless for the benefit that they bestow on us, the patients. And for what do we give them in return? A lot of times it's abuse. So thank the medical staff, recognize that everyone has bad days. Everyone has bad days, and try to engage in as much grace as you can walking about your day. Caitlin Fletcher, is there a reason why Chad is bringing up Shapiro's wife? Did I miss something? Shapiro's wife made some comments. I didn't find them as offensive as a lot of people did. She was pushing back in a chat. Now, it might have been a time, place, and manner thing. She was pushing back in a chat and kind of saying this might not be the perfect case for this type of argument. And I'm not going to say that those were, I mean, they might not have been appropriately timed, but gotta keep in mind, people are talking remarkable amounts of crap about Shapiro. And I don't like that. I really don't like that. He's an attorney with a job. And the fact that we let all common decency, respect, and decorum just leave the fucking room when the person's the attorney on the other side is really kind of frustrating to me. And imagine for 1 second that you're the spouse of this person and everyone on the internet is making fun of him and throwing stones at him for doing his job. Is that going to bother you? Might that push you to say something less gracefully or less than graceful? I saw the remarks. Could have been better said. They probably shouldn't have been said. I'm not going to come down and bash her. I'm not going to even pull them up. It's a tough case. It's a tough case for everyone involved. And I really hope that both sides can show a little bit of compassion to the other. And I don't mean like the hospital entity, but guys, man, there are physicians and treating doctors and people that are involved in this litigation who were just doing their jobs. Can we recognize that for a second, please? People that were just doing their jobs and all of a sudden get dragged in to accusations of malpractice. I mean, like everyone got deposed. Everyone got deposed and raked over the coals. I just think we got to show a little grace. Emily Ippolito, was she classified as an expert? Why is she allowed to take her notes without asking? Expert classification, she was. Karen G, yes, chancla is informal, short for chancleta. Yeah, the chancleta. That's what scared the fuck out of me. Christopher Norris, by not doing cross, they've taken away her chance to shine. I don't disagree. OB Nurse Chelsea, that question made me a little angry. If they had called security / police department because Beata had said the dead heaven comment, they would be mad about that too. Yeah. OB Nurse Chelsea, judge, any questions for the jury? Jury, yes. Defense in their best Anderson's voice. Why? Possible. Theother Latina. The other Latina. My God, my brain. I need meds bad. Some nutritious foods for you since you're pushing yourself for us. Thank you very much, the other Latina. Harley IQ, a child using medical terms stayed in bed. Stayed in her mind. 1, kids with chronic illness learns terms. 2, I'm an RN and kids use medical terms. Not default red flag. I agree. That comment was made quite a bit, and I think the plaintiffs had already kind of got ahead of that ballgame. Solo YOLO, Teppa knew immediately who Smith meant by KG and didn't ask about Maya current status. Obviously discussing frequently. RN juror surely got this. She might have. He or she might have. Jonathan Duger, that wasn't a shot. Keeping with World War II analogies, that was a Hiroshima in 1945. That was a shot across the bow. M. Young, this is Recovery Addict Zoom dictation. You got it. MEZ, you do not repeat too much. That is an ADD thing. I actually appreciate it. Thank you. Just a red girl. I find it interesting they decided to wean meds after talking to Sally Smith. I did too. Back to who was leading whom, and their HIPAA violations are disgusting. That part, I think, is bothering a lot of people in the jury a lot. I think it happens more commonly than we think, but I think it is still disgusting. It's a nice reminder to people who are in that field. Be careful about what you're doing, guys. You have people giving trust to you. Don't just throw it away. Like I say, I always say this: text and email as if one day it will be read out loud in court, because someday it might. KBF, ketamine girl is a HIPAA violation, as is using personal cell phones to text Chisme about patients. Jay Hatch is violating HIPAA right and left. This is bothering a lot of people, and it bothered me too. K-Rab, the look she gave when there were no questions on cross said she is afraid to question me. He's afraid to question me. Jury said, well, we aren't, and I think he was betting for that. Welsh lady, you explained it perfectly. Thank you, Rob, from the bottom of my heart. Thank you, Welsh lady, and I'm sorry it took me so long. I promise you, I do save them. I do star them. I try to bring them up, and I do try to answer all of them. Thank you for being here, and thank you for the great question. Automata, why? Why would she bring the text back on screen? That was my question too. Bonbon, Dr. Sanchez dug a hole, the text, built a ladder, the testimony, burned the ladder, her excuses for the texts. Kind of. Icosaplex, thank you for the gift of memberships. Amy Rodriguez, I appreciate this jury. Island, thank you. Shot clock at the end of the day. Plaintiff, 59. Wait, hang on. 59, 40. Okay. So this is the revised shot clock. Thank you, Island, for this. It was 55. They added 4 hours to both sides. Plaintiff has 59 total hours. As of today, they have used 48.15 hours. They have 10.45 remaining. Anderson, tighten the cross. Pick your witnesses, go in hard on the ones you need to, quick approach with the other ones. Don't try to score every point. The jury's with you. The jury's going to ask the questions. You learned a lot today, I hope. Defense, 59 minutes minus 22 minutes, 36.55 remaining. Defense, you have a very, very large advantage on the time scale. Use your witnesses effectively. Use redirect more effectively. Allow Anderson to play off the jury. You can play that game too a little bit. So don't use all of your questions on direct. Maybe save a few of those little ticket items for after the jury questions. Now be strategic about it, because you can land a few punches towards the end. It's a good question. Remaining mistrial requests, counter plaintiffs are 2 withdrawn, defense 4, objections 1,144 objections. Thank you, Island, for that stat. That's an awesome stat. Susan Walls, regarding the F-bomb, it's not likely to me she brought it up. She was asked, why is everyone jumping on her? I'm confused. The profanity part was brought up by the defense. They brought it up. They brought it up to say that Maya was being profane on several occasions, and they brought out the person about whom and to whom she was being profane to testify. The jury was proper in asking that question. AG, having a rough day, popping in to make sure I don't miss it. Thank you again for these, Rob. You've helped me so much with understanding the law. Thank you, AG. Janet stuttered, I have no problem with anyone in that courtroom, and like some cases, I dislike many. I think that everyone in the courtroom is comporting themselves appropriately. Melanie Hideki, my hubby over 40 years has ADHD, and he is the most productive man I've ever known. He lives with lists. Embrace your ADHD. It is a superpower. Cheers to all of my ADHD spicy brain brethren. Superpower. Embrace it. AG, as someone with severe chronic pain and multiple medical issues, you've helped me feel seen. Being medically complicated is hard, and how we're treated is discounted. This is a shining, necessary light. Thank you, AG. Robin Mallow, thank you for the super sticker. Tess Hurd, thank you. I'm covering this case on my podcast, and your videos help me understand what's going on the legal side. Thank you, Tess Hurd. That is awesome. Thank you. Please go check out Tess Hurd and her podcast. Jam, almost a year. There you go, Jam. 11 months, just a bit shy. Dawn Burke, gifted memberships. Thank you very much. Melissa, thank you very much for the very kind super chat. Doctors, cops, teachers, among other professionals, are susceptible to compassion fatigue. So accurate. Same with lawyers and judges. It's obvious when cops have it, but not as obvious for other professions. We need more awareness of compassion fatigue. Melissa, What a remarkable and appropriate comment to go out on. For those of you that are watching, I'm going to roll the outro because the outro is something that going on with that point is a reminder to have some compassion in your life. I make a comment quite frequently that when you are struggling in life or when things feel overwhelming, go make something. Take some time for yourself. Go make something. You'll feel a little bit better. I make this comment because I make things. I make things in a shop, and I make pens, and I make tables, and I make coasters and different things out of wood. I that's what it calms me. That's what brings me back to center. That's how I process some of the emotional complications of what it is that we deal with in this legal profession that's so messy. So, without further ado, I will see you all tomorrow. Enjoy the outro. I certainly enjoyed making it. I bid you all good evening, and I hope to be back tomorrow with another recap of the next day. I always forget. Please don't forget to like. We are on our road to 200,000 subscribers. I would love to get there by the end of this trial. You can hear my voice. We are on the road to 200,000 subscribers. We are on the road to 200,000 subscribers. If you wouldn't mind subscribing, if you do like the content, it means a lot. There's no cost to you at all. If you hit the like button, it would mean a lot also because it helps YouTube realize that this is a video, this is content, this is information that should be shared. So please do that on your way out. And until next time, have a wonderful evening. Good night, all.